Good morning, colleagues. Mandla? Is that the meeting started?
Someone's got recording.
Good morning, everybody.
Good morning.
Good morning.
Morning.
Chairperson is trying to connect to the meeting. As we all know that we are struggling with load shedding, and some of the colleagues are struggling to log in. Just be patient. As soon as she has managed to log in, we will start the meeting. I will also request those that have their videos
Good
on
morning.
Can I request those who have videos on to switch them off for now? You will only switch it on when you are going to speak, because that's one of the things that are making the network to be very poor. Just switch it off for now. Then when we are going to speak, you will switch it on so that we know you, we can see you. Thank you so much.
Lebu. That is systematic.
Good morning, everyone. My apologies for that. the system keeps on kicking me out. I've just experienced load shedding for social development, and I will be chairing this session of the seminar. Unfortunately, I cannot have my camera on now since I had to switch my gadgets. So I hope that you will bear with me, but as soon as I'm sorted out, I will be able to then interact with you so that you can see who you're actually speaking to. I do gather that there are some few people who are also struggling with connectivity due to load shedding. But I hope that it and we are supposed to proceed. So I would like to take this opportunity to welcome all of you to the series and really appreciate that all of you were able to make it this morning under difficult circumstances, of course, but you were all able to hit the call running and join this important seminar. I want to acknowledge the following people. Firstly, the members of the portfolio committee who are here with us today, members of the South African Judicial Educators Institute, the Gauteng Family Forum, the Department of Justice and Correctional Services. I think we do have the presiding officers with us here today. The South African Social Security Agency, SASSA, our partner. The Gauteng Department of Social Development is here. The committee stakeholders and the non-profit organization members that are here, as well as the National Department of Social Development. You are all welcome and you are free to participate in this important seminar, and I hope we will all benefit from your wisdom. I am going to, at this stage, allow all the members that I've introduced to introduce themselves. And as they introduce themselves, if possible, they can just switch on their cameras so that we can see their faces. Introduce yourself, and thereafter you can switch off your camera. And only the person who will be on the platform will be allowed to switch on the camera. So for now, I would like to invite the members of the committee to introduce themselves if they are here. Members?
You, if you can.
Yes, members of the committee, you can introduce.
Thank you, Chairperson. Good morning, everybody. My name is Togozile Makakula. I'm the member of the Portfolio Committee on Social Development in Gauteng. Thank you.
Yeah, the next one.
Chairperson, thank you. It's Member Nteche, also member of the Portfolio Committee. Thank you very much.
Thanks, Member Nteche. Next one.
Morning, Chair. Member Engelbrecht, welcome to everybody. It's a privilege to be here. Thank you very much.
Is there any other one present? I can't see here from my side. If there isn't, I will then proceed to have the GPL committee support staff to introduce themselves. I know Sipho was struggling with connectivity, but if you are here, please introduce yourself, switch on your cameras.
Good morning, Chair, and honorable members and colleagues and participants. Can you hear me?
Yes, we can hear you.
Yes, I'm struggling with the laptop. I've connected with the phone. My name is Sipho Mwala. I'm the senior coordinator for the committee. Thank you very much.
Okay, next one.
Morning, Chairperson. I'm not sure if I'm audible.
Yes, you are.
Morning, Chairperson, members and colleagues. My name is Noveliso Mtebi. I'm the Senior Information Officer for the committee. Thank you so much.
Okay, thank you, Noveliso. Next one.
Good morning.
Good morning, Chairperson.
Okay,
Yes, good morning, Chairperson. I'm Pindi Mpemvu, SCTW of Lisedi, Ratanda. Thank you.
Good morning, honorable members. Good morning, Chair and stakeholders. Good morning, colleagues. My name is Susie Wepanjwampalo. I am the Group Community Coordinator for the Social Transformation Cluster. I'm assisting at the GPL, and thank you, Chair, for having us that opportunity to introduce ourselves. Thank you.
okay, is that all? Yes. Then let's Dimakatso.
Good morning, Chairperson. Good morning, colleagues. My name is Dimakatso Mongwenya. I'm the service officer of the committee. Thank you.
Good morning, Chair and honorable members. My name is Kekana from Hansard and Languages.
Thank you, Kulekani. And thank you, all of you. Let's then move on to the South African Judicial Educators Institute. If there are representatives from the institute, kindly introduce yourselves.
Good morning, colleagues. I'm Teresa Horn. I'm a senior magistrate, but also the judicial educator at the South African Judicial Education Institute. Thank you for having invited us, and it is really trusted that this will be a productive session. Thank you.
Thank you, ma'am. Anyone else? Are you alone, Teresa?
Yes, Chair, I am alone. However, I am aware that some of my colleagues as magistrates are also on the webinar. So if you can maybe just call, for instance, Mrs. Pravina Lazarus ought to be here.
Okay. No, I think we will stick to all those that are in this platform for now. For introduction's sake, and as and when they come to the platform.
Chair,
Madam Chair, I am online. I am online. I don't know if you could see and hear me.
Members from the Gauteng Family Forum introduce themselves.
I'm here, Ms. Kekana. Can you hear me, Madam Chair?
Yes, can you see? Yes, I can hear you very well.
Okay, thank you. I'm Pravina Lazarus. I'm the senior magistrate. I'm the senior magistrate at the Springs Magistrates Court, as well as the chairperson of the Gauteng Family Forum. Good morning, honorable members. I'm honored to be here. I know that some of my members and members of the judiciary are also online. Thank you for the invitation. I hope this will be a valuable session.
Thank you. Thank you very much, Lazarus. Who's here from the Gauteng Family Forum? Are you alone?
No, they are members of the judiciary.
Let's then move on to the Department of
online.
Justice and Correction.
Good morning, can you hear me?
Yes,
morning.
we can,
Yes,
Mogi.
Thank you for the invitation. My name is Mogi Naidu, Senior Magistrate, Pretoria. Thank you.
Thank you. Thank you very much, Ms. Naidu. Can we then have representatives from the Department of Justice and Correctional Services. Is there anyone representing the department? If not, I think as soon as they join us, they will get an opportunity to introduce themselves. Let's then move down to South African Social Security Agency, SASSA. Any representative from SASSA?
Good morning, Chair, and good morning, honorable members, our major stakeholders and colleagues. I am Zodwa Mvulane, the Regional Executive Manager responsible for Gauteng, Limpopo, and Northwest. And Chair, may I also use this opportunity to indicate I am with my colleagues that will introduce themselves, but request humbly so that I will sneak out of this meeting after we have presented due to the fact that there are other competing interests. Thank you, Chair.
Thank you. They can introduce themselves then. Ms. Soto.
Morning, Chair. I think my reflection, the light here at our regional office, it's not very good. Hopefully next time it will be better, especially from my office. I am Tebeleto Maheta, the General Manager for Grants Admin. And thanks for having us. And I'm really excited to see that there are also other colleagues from Department of Justice. Thank you.
Thanks, Tebeleto. Who else is here from SASSA? Okay, let's get representatives from the Gauteng Department of Social Development.
Good morning.
Gauteng Social Development.
Good morning,
Chair,
colleagues.
And honorable members and all the invited guests. My name is Tembeni Mhlongo. I am the HOD of the Department of Social Development. Thank you. And I think I have got also other managers from the department. I'll humbly request them to quickly introduce themselves.
Thank you, HOD. Yes, proceed in that fashion. Members from the department, can you just introduce yourselves as well?
Good morning. Oh, sorry. You can go.
Okay, go, Tebelo.
Okay. Good morning, Honorable Chair and members of the Portfolio Committee. My name is Tebelo Mkondo from the Department of Social Development. I'm the Chief Director responsible for Social Welfare and Specialist Services. Chair, pardon me, I'm being load shed, so I've connected from the phone. So and the call keep on dropping as well. Thanks, Chair.
Okay, noted. We are also load shed. I'm also connecting from the phone now, as you can see my background. Yes, who else is next?
Good morning, Chairperson, members of the Portfolio Committee and the Judiciary colleagues. My name is Keban Tuampi. I'm from the Provincial Social Development Director responsible for children's services, including foster care. Thank you, Chair.
Good morning, Chair. My name is Phumla Nkosi. I'm the Regional Director responsible for Ekurhuleni. Thank you.
Good morning, Chair and colleagues. My name is Kosim Sibi, stationed at Provincial Office responsible for alternative care. Thank you.
Good morning, I'm Ida Strydom. I'm the Acting Regional Director for Tshwane Region.
Good morning, Chair. I'm Doko Bedi, the Regional Director for Western Region. Thank you.
Good morning, Chair. I am Kumo Khomeswana. I'm the Acting Regional Director for Sidiben Region. Thank you. I am.
Good morning, Chair. My name is Tebogo Morokani. I am the manager within the Office of DDG for Social Welfare Services, Community Development Regions and Institutions within Gauteng Department of Social Development. Thank you.
Yes, on the platform. Thank you. If that's the case, then let's move on to the committee stakeholders and NPOs that are here. If you can introduce yourselves as well, that would be appreciated.
Yeah.
Anyone from the NPO sector?
Good morning. My name is Portia Serote. I'm a professional social worker working for a human rights organization named Access Chapter 2.
Chapter 2.
Good morning, all. My name is Cyril Lengata. I'm from the LGBTI sector in Gauteng. Thank you.
Thank you, Sidwell. Pumzile?
Yeah, Mike.
We can hear you.
Oh, you can hear me?
Yes, you can speak.
Oh, good morning, colleagues and honorable members. My name is Pumzile Stole from Gauteng Social Development, responsible for alternative care.
Thank you. We are making progress. Can we proceed?
Good day, colleagues, Chairperson. I'm Sekhala Israel. I'm from the Greater Benoni Child Welfare and the Social Work Supervisor.
Okay, thank you so much, Israel. Is that all? Yes, if that's it, then we can have members from the National Department of Social Development who are here. Let's just see who is with us today. National Department of Social Development, is there anyone? Okay, if there isn't anyone, then I'm sure they can also introduce themselves as and when they come. But safe to say that we really appreciate all of you, and thank you very much for Yes. Yeah, sorry, I was muted a bit there. I was just saying that we are all welcome in this forum this morning, and you are really appreciated having to spend time with us this morning. I see, Mishak, your hand is raised. You can come in. Mishak, you had your hand raised. Okay. No, I think probably it was a mistake from your side, Mishak. We will then proceed with the opening remarks so that we can then start with the business of the day. I think you all have the brief agenda with yourselves, and I think all those that will be making presentations are aware of what they are going to be talking to. As you are all aware, colleagues, that the issues of care and safety for children remains one of the most important focus areas in our government. And it is through these platforms and our on setups such as the portfolio committees where such issues have an opportunity to be given special attention. And as the portfolio committee on social development in Gauteng, we are aware of the many challenges that our vulnerable children in Gauteng are faced with. Giving attention to foster care today does not suggest that we have neglected other areas, but it's just that we decided to focus on this one of these important subjects. And one of the reasons we have arranged such a gathering is that as a committee, we have been observing the repeatable reasons outlined by the department around foster care placement processes, especially around the increasing number of cases that are yet to be completed. In as much as we do not condone children being placed for the purpose of reporting, we want systems that will ensure that children are placed in loving and conducive family environments. We have also realized that our case load based on the information provided by the department is actually very high, and as such cannot be acceptable when government has set up policies and legislation to enable effectiveness. Also, the recent COVID-19 pandemic has also brought its own challenges and has dictated a new way of operation, which has brought a rather slow pace than it was before. Foster care placement and provision of psychosocial support are some of the programs that the Gauteng Department of Social Development has committed to contribute as part of promoting the rights of children. While the department remains the sole custodian, the Department of Justice, through the children's courts, the non-governmental organization, academia, and some of the key stakeholders on foster care related matters are here, and we value them. The children's courts have been identified as one of the key stakeholders in the finalization of cases through the provision of court dates and issuing final judgments based on the required evidence. Should they be insufficiently resourced, it may also delay the finalization of cases. The committee has engaged with the department on these issues and also explored their role and that of its stakeholders. Noting the challenges faced by the department on the shortage of social work services, there is a need to also investigate such. Another concern which was identified is the lack of practical data. That is the realistic nature of foster care cases that we have in Gauteng, whether they are having court dates or not. And it is such information that we feel that as a committee, we need to have systems in place so that we are able to record them properly and accordingly. Even though there has not been tangible data on foster care applications and placement cases and the response rate of completed cases, the committee has noted with concern the reasons for the negative deviation reported by the department on the foster care placements. And this has always been attributed to difficulties in obtaining relevant psychological reports, different interpretation of the acts by the different courts, and recently the regulations brought by the COVID-19 pandemic. Also, the committee has noted that the department has reported to be in constant contact with its partners on foster care related matters and have reported positive feedback. However, there are still uncertainties on whether these initiatives are addressing foster care placement backlogs with the speed it deserves. And let me indicate that the reason that we actually convened this webinar is actually the continuing negative deviation from the target and the unchanging reasons provided by the department on the foster care placement. And I think we need to really drill down to that and get the reasons why. And that also necessitated the portfolio committee to conduct oversight as well as engage with key stakeholders, which is also part of our public participation mandate. But not only to review the existing processes which are in place, but also to identify areas for improvement so that service delivery can be improved ultimately. Therefore, the objective of today's gathering, which has been communicated through our invitation on the advert, I'm sure most of you will recall, is to actually provide an understanding of the causes of the backlogs, one, to study and review the current processes on foster care applications and placement, and also to identify problems that need to be addressed for more efficient and effective service delivery. We would also appreciate if we can, through this engagement, get an indication on the actual number of cases received per month, if possible, the systems in place on the application processes, the partnership in service delivery, if it is there, and if it is there, does it assist in dealing with the backlogs? The human resources, even at regional level, are our social workers able in this regard? Are they sufficiently capacitated and equipped to deal with such cases? The general organizational resources, if you can also outline that, as well as the interinstitutional challenges that you might experience in terms of the children courts and SASA as well. And the committee would really appreciate if through today's engagement, we can be able to honestly speak about the real challenges that affect this department or this sector, noting that the aim is not really to find fault with anyone in particular, but rather to come up with joint initiatives which will be practical in ensuring that children in our province are placed in foster homes that will be beneficial for their well-being in our quest to care for them. So on that note, I would want us to start with the seminar, especially the presentation from the SASA. I will start with Ms. Zodwa Mvulani, the SASA Regional Director, who has already introduced herself, to take us through the implications of the Northern Gauteng High Court ruling, the challenges and areas of collaboration with Department of Social Development, as well as the foster care grant online system. And after Zodwa, we will take a presentation from the Department of Social Development by the HOD. And after the two presentations, we will then engage and then we'll proceed with the other presentations from the other institutions. Over to you, Zodwa.
Honorable Chair, I think Ms. Mvulani has left us as requested. because she has to attend another urgent matter. Also, unfortunately, it clashed. That was arranged by head office. So we had to split between ourselves. At least if she's there, then I'm going to be here. And I think that apology will be accepted. Sipho, I don't know now because you are on a phone, whether you are able to show the slides. And the rights, I think, have not been shared, so I can't.
Chair, Member Nsege?
Yes, Member Nsege? Yes, you can speak, Member. You are muted, Member.
Chair, I'm saying if I can be given rights, I'm happy to share the slides. I don't know if I have sharing ability, just to fast track the process.
Yeah. Let's check if Sipho can hand over the hosting rights to you so that you are able to share. Oh, there it is. I don't know who's sharing now, but however, there is slides showing on my screen. Thank you very much. You can proceed.
No, that one is for social development.
Oh, that's for social development. Sorry.
All right, let me try and share. I've got both of them here. Is it sharing, Chair?
Yes,
yes, yes. Thank you.
Thank you, Ma'am.
All right, let me mute myself.
Yeah, just make a slideshow for us so that it's bigger.
Thank you. I'll proceed. Thank you, Chairperson and members and colleagues. The purpose of this presentation is to provide to the Portfolio Committee as requested on the implications of the North Gauteng court ruling that was extended in October 2020 from the 2017, the initial one, its implications thereof for ourselves and DSD, and to provide status in terms of that court order from the side of SASSA in terms of the outstanding court orders that we are having on the system and the progress that has been made per each district as end of April. And we also have identified some challenges and made suggestions in terms of the improvement that has to be made. I'll also summarily maybe share with you an initiative that SASSA has already taken on the online management of the foster care that is underway and it has been implemented. Thank you. The presentation will look at the purpose. We have looked at it, the background, the implication.
Sure.
Can we request Ma'am Pule? Oh, thank you.
Ma'am
We'll
Pule,
also
mute your mic. Pule? Yeah, thank you. You can proceed, Tebeleto.
Thank you, Ma'am. We'll then look at the status of the court orders, FSET, progress to date, the gaps and challenges identified, areas where we think we can improve and conclude, and a few recommendations. We just briefly touched on the background, and I think most of us might have read, and my colleagues from DSD are very aware, and the colleagues from Department of Justice on this matter. It started in November 2017, wherein the Center for Child Law launched an application in which it sought a declaratory order regarding the challenges facing social development in the administration of the foster care systems, as at that time, there were a number of outstanding foster care, and SASSA wanted to lapse the cases because as per the Social Assistance Act, when a court order has reached its time, SASSA system would automatically lapse, whether it's a child reaching 18 years, the child could be at school, or a child who is still in the foster care placement. When the date of expiry of the court order that we have at hand, then SASSA would lapse those cases. And on the basis of that, there were lots of children who still nationally had those lapsed court orders, and the Center for Child Law then took us to court, the ministry and SASSA. Out of that court in Gauteng, at the time, we had about 85,643 that then were given a 2-year extension from the High Court ruling. By November 2019, when the court order came to end, we still had a total of 36,378 that still needed to be attended to. This just says the court order of 2019 was then extended for a period of 12 months, and the legislation then needed to be amended, and a comprehensive legal solution regarding the foster care system needed to be put in place as per the court order ruling.
We are losing you a bit there, Tebelezo. Maybe if you can just move around a bit.
Oh, sure. Thank you, Chairperson. I'm in the same desk. Maybe, am I better now? I'll move the computer.
Yes, you are.
Okay. Can you go to the next slide? In October of last year, the number of children's court order that had expired was still very high, and we had still about 57,488. And these included all cases which had a valid date in the past, which means the date was valid, but it was in the past, as well as those which had to expire, were going to expire, including the end of September 2020. Maybe let me explain. It might confuse in terms of how SASSA processes work. You would find that at many a times, some of the court order would have expired, would expire by, let's say, June, July. But the child is reaching the age of 18 in December. So what we would normally do would take all that information and give to DSD to say, in this
We're losing you
financial year,
there. You were saying expire in July and the child is reaching today.
18 years. If we have not received a court order, it's supposed to, at the age of 18, that child should have to exit the system automatically. We cannot extend unless there's a new court order or the child is still at school. Can I continue?
Yes, you can continue. It's just that you keep on breaking. We're missing some of the issues, but we do have the slides going through, so you
I'm
can.
sorry. It means I'll have to walk around. I'm not sure. Being confined in an office.
As I was saying, you can mute, Sibongile, mute, so that we can hear Tebeleto properly.
I was still saying, Chair, then in October, the Minister of Social Development, all the 9 provinces, premiers and the MECs were then, the matter was brought in front of the North Gauteng High Court in November 2010 to request for the extension of the ruling of 2019, so that we continue with the payments of those children and to ensure that the services are still rendered. And then from that court ruling, which is the recent one that we are working from, we were given an extension of 24 months. Both SASSA and social development, to work on those cases. Being that we need to ensure that all foster care orders that were referred to in the court order, meaning the previous one, not new, are dealt with and resolved until the date of which such orders would lapse. What is the implications thereof of the said court ruling for SASSA? Is that any foster child who is at the date of this order on that date is in existence or has lapsed due to non-extension shall deemed to have been extended. It means if as SASSA there was a court order that had lapsed, we needed to extend that court order for a period of 36 months from the extension. That means we look at that court order. If the court order from 2017 would look at when did it lapse, and if we lapsed it in 2019, was it still valid or not? Alternatively, until the end of the year on which that child turns 18. As I said, if this child turns 18 now in June, we don't lapse it. We lapse it at the end of the year, which is in December, and shall be deemed to have extended and shall be valid for a period of 36 months from the extension since 2017 until the end of the year on which that child, subject to foster care orders, turns 18 years old in terms of Regulation 28(3)(d). SASSA was then directed to effect continued to effect, not affect, sorry, payments of all foster care orders referred to in this order until such orders lapses. And SASSA was faced with a High Court order of foster care backlogs, which were generated because of large amounts. For example, of recent, we have identified that it's one of the high-risk areas that we are identifying on our emerging challenges, where we find that there are court orders as late as 2013 that were never brought to the attention of SASSA by the foster care parents. And now with the extensions and the court rulings, a lot of these are surfacing from where we don't know, and most of them are coming from NGOs. We've just made an example where we had to pay this parent 68,000. And the challenge being, how is that money going to be monitored in terms of its usage for the benefit of the children? There was also a recent case wherein also we have been found wanting, because when you have to calculate an amount which is over 2 years, you have to bear in mind the increases that had been made in the previous years. And because of human nature, you find that at times our officials miscalculate, and we even had a audit finding of one case of Ekurhuleni, which we had to pay about 133,000. The implications, again, is that some of the beneficiaries are being defrauded by SAPO. We had one recent case wherein the beneficiary was paid, I think, about 56,000. The person went, and because it's in the card as we process, and because of other challenges of lack of supervision, the person went and the person was paid only 10,000. We then established during our processes that this person was shortchanged by SAPO and was only paid 10,000. And that matter is between SAPO now and head office, because it's a fraud. The person was defrauded, and some of the implications on these court rulings. In order to address the differences in the numbers between DSD and SASSA, this is an old tug of war, if I can call it. I think the colleagues here will recall that every time, because we don't use the same data system, our mainframe, which is called SOCPEN, uses a different, using an ID number and the date of the expiry date of the court order. And every time we would not agree in terms of the numbers and would not always be able to reconcile the numbers and the details list as per each district, because we are not using the same system. Where are we now? In terms of the status of the court orders in Gauteng as of April, that are going to be valid for payment up until April next year. In West Rand, we have 2,027. In Sidibeng, we have 3,159. Ekurhuleni seems to be the highest. They've got 6,087. Tshwane has got 4,650. And Johannesburg got 4,040. Progress received. Before maybe I talk to progress received, I will maybe touch on the invite, which was saying we need to also touch on the operational plans for SASSA. The operational target for SASSA in terms of foster care, unfortunately, it talks to the number of that what we receive. And I think it was changed on the basis that previously we would have a lot of challenges to process foster care expired court orders, because we reliant and solely depend on that what we receive from our sister department. As a result, our target is always just saying you will process 100% of that what we receive. If we have received 100 court orders, the expectation is that within a specific time, those court orders should have been processed and put back into payment. It does not have a number. It is percentage of that what we receive from a Department of Social Development. To date, that what we have received from West Rand, 32, sorry, Sidibeng 50, Ekurhuleni 135, and this is in line with the above in terms of their outstanding as per our data. North Rand, we have received 83. Johannesburg, we have received 102. So it means in this financial year, as we process, we have only done 402 of the expired court orders. What are the gaps and challenges that we have identified? We have since, and I referred to a Ekurhuleni case, that there is challenges and some lack of cooperation from some of the NGOs in the area of Ekurhuleni and Johannesburg. We recently had a case from an NGO, because one of the requirements is that when a person brings to SASSA an expired court order, we require a motivation and an affidavit from the social worker who was dealing with the case or the social worker who referred the client. More if it's an expired court order, because they need to explain themselves why would the person sit at home with a court order of 2013 and bring it in 2021. In one of the cases, the letter from the social worker was saying the parent has got psychological problems, the person is afraid of crowds. And that was the reason. And that is why we are saying in some areas there is lack of cooperation. And we wanted to understand, then if the person is afraid, why wouldn't that matter be referred to a social worker? And if needs be, as SASSA could have arranged for a home visit and take that application on time rather than to wait until the court order had expired. In some instances, you find that we had problems of untraceable foster care parents, where the child either has left the initial one, and if the court order in terms of the first placement it's with somebody else, and the parent who's now having the child says, I'm having this court order, we would have challenges because it has to go back to social development and be taken back to court. I've spoken about a lot of fraud that is happening around there, and we are really becoming concerned of a lot of expired court orders that are resurfacing, which we don't understand. Why would a parent sit with a court order for 5 years, 6 years, and now it's only being brought to SASSA now? Because I think with the change of the legislation, it's known that irrespective whether that court order has expired, SASSA, we are therefore obliged to pay it irrespective because it was given at the time. That talks to the delays and in the submission and resulting in large amounts of payments to the foster parents. We also at times have delays from ourselves in terms of capturing of these court orders, because what happens if it's a large amount, you'd find that the limit of a supervisor at a local office is about 10,000. If it's above, it has to go to a district. If it's above 50,000, it has to come to myself with a submission and that letter of a social worker. And those causes undue delays to the beneficiaries. The non-common understanding of processes by SASSA, and especially when it comes to the large amounts, because you'd find that we now apply different means test, I mean, a system in terms of the means test, because the amount itself increases annually, especially in the calculations of these large amounts where the court orders had expired. And this has led to some audit findings from our side. And where there are no court orders, it also then would result in irregular expenditure and audit findings as well. Delays in the cancellation of foster care discharge and fraudulent cases resulting in overpayment, as I alluded to one, where the new parent says, I'm the new parent, and brings an old court order. We can't pay until it goes back to the court and says this belongs to this person. And unfortunately, in that instances, we cannot. And in some instances, it becomes an overpayment, which now we cannot be able to recover if we discover that the child is no more living with the initial foster parent. Management of databases is time consuming due to the high targets, and it's a manual processing for DSD because they don't have an automatic system that would assist ourselves if we had that, wherein we would have a system that talks to the court order as it is issued by Department of Justice, then it's captured, it goes to DSD, it's automatic, or it's scanned, it comes to SASSA, it also becomes automatic. It would assist a lot in terms of the manual registers and the manual processing of these foster care orders. I think one would also, as the chairperson alluded to, we have since realized internal challenges of staffing in monitoring some of these foster care parents with our sister department. The next one. Areas of improvement, I think you touched on them, Chairperson. We need to look at better communication mechanisms and engagement between all the various stakeholders, in particular our NGOs, DSD and us, and Department of Justice in the management of this specific extension of the court order ruling by the Gauteng High Court. Also improve communication between ourselves and SASSA, because we also have to most of the time agree and tally to say this is the person that I'm paying, and DSD would have to verify, yeah, I still have this file, I still have this person. And unfortunately, because we are dealing manually, and I think COVID also contributed last year. Just not long ago, I was talking to Ms. Ndwampi to say we owe each other a visit and a workshop. And I think the portfolio committee has now done that before us. And we're talking to say, guys, it's the beginning of the year. We have not met. We need to meet and compare notes. Who do you have and here, who do I have? And this, we used to have it on a quarterly basis. But I think last year, because of a lot of challenges, we lacked a bit. The linking of systems, as I've said, of the various stakeholders, there is a urgent need to say, as government, as we process these, there's an urgent need of linking systems and linking data so that we're able to see who's fraud, who's still valid, and we're able to validate all these court orders, starting from Department of Justice, where they issue out to DSD and ourselves. Areas of improvement, again, we're looking at commitment by our sisters, social workers, to prevent backlogs and a better management of their caseloads, as said, because the worry is that after paying this person 133,000, is it effectively used for the benefits of those children? The very same case that I alluded to of 68,000. The recent case where the foster care parent, we found after some time that was defrauded by SAPO. The importance of tracing and tracking the clients, the submission of monthly progress meetings reports between ourselves and DSD, and this is also monitored and coordinated even from a national point of view, because between SASSA, national and DSD, there were also these meetings where we would also participate as provinces. I've spoken about a consistent monitoring and evaluation so that we take this as a project, because it's got a start and an end, so that we're able to measure ourselves and review that by this time, this is where we are. Are we going to stay within the 36 extension months? I think I've taken that is part of the reputation, active participation of regions. There are structures and we are saying these structures need to really start being revived. We know COVID-19 pandemic put us off guard, and a lot of these were not happening last year because we used to have these regional collaborative and meetings and reviewing of our statistics, and from region it would come to province and it would come to national, and we then would have to crucially look at how we revive these. And the other one is awareness and change management with the implementation of the foster care automation, which I'll just speak to it very shortly, because it's a process that SASSA has undertaken. And I think we are just saying, bringing that awareness to the members here and to our colleagues. Mensache. In conclusion, I think we are saying the cost of continuing to pay foster care children should be weighed against the social cost of leaving these already vulnerable children without support. You cannot now, as the court found, that because of the cost implications and the audit findings that we're having, and weigh that less to the vulnerability and the need for continuous support of these children. These children being awards of the states, and by not extending the court ruling, the state would have been seen to be derelicting its duties in the protection of vulnerable children. It is particularly relevant given the slow progress with the amendments to the Children's Act, and we're hoping that now is going to be, it's finalized, it's going to be implemented. And while also awaiting the extended child support grant, which is catered for in the amended social assistance bill, and we're hoping it will also alleviate some of these pressures. I think the chairpersons also alluded to the fact of what is backlog. In the previous deliberations between ourselves and DSD, would say to them, where we are sitting, a number of children that are getting child support grant are children that were supposed to be getting foster care. But because of the capacity, then the social workers would at times say, okay, we are still waiting for this, I'm still doing 1, 2, 3, 4, and the parent comes to apply for a child support grant, which disadvantage that child in terms of the amount. And the second disadvantage is the fact that when that child support grant reaches 18 years, we now leave the child out. There isn't any extension, unlike in foster care. However, this also is required in terms of the regulations to be able to implement and confirmation of funding from National Treasury that the backlogs that we are supposed to be paying, SASSA and DSD needed to appeal to National Treasury as well. We are recommending that DSD to engage all their NGOs in where they are dealing with to be able to participate in these temporary suspension where foster parents are untraceable, active participation in all of the management of this project, providing support and guidance, regular and continuous supervision by social workers with these NGOs, and monitoring by both SASSA and DSD, and consequence management for non-supervision on both SASSA and DSD, because at times I think we have felt as if our colleagues just, as I would say, maybe get away with murder. You find that there was no supervision at all, and hence we got the very lame excuse, if I can put it that way, from the social worker, from an NGO, when we requested a detailed report why this parent couldn't bring the foster care, the court order at that time. Chairperson, I'll stop here, and I'm not sure whether you can allow me to go to the automation. It's very, very, very short. I'm not even go to the background.
Yes, you can proceed.
Okay. Mensache, I'll ask you to, let's pass this one. I think I'll summarize the current challenges wherein SASSA has, in line with automation of our processes and digitization, has embarked on a lot of them. We already have started with the online application, and with that, they also looked at other processes, internal processes, to try and manage and get to some internal controls of our processes. I think the issue being that we have these processes that are not shared between Justice, us, and SASSA. And I think I've said in the previous one that we have these processes that are decentralized through manual registers. And in most of the time, it had challenges when we have to reconcile that I received. The social worker said it was brought, and our guy says we don't find the court order, and you find that maybe it was misplaced, and the poor foster parent are torn in between pillar to post. And in this is trying to address those issues, that the automation of the registers to enable the business to be centralized and improved on reporting, that they currently there are no integrated mechanism. I spoke about that. It's all manual. Court order is given to the parent from DSJ, goes to SASSA, DSD, it comes to SASSA, and really in between something happens. So this is aimed at supporting the end-to-end process for all the newly issued and extended orders. There is fragmentation, I've spoken to that, and the issue of reconciliation, that overall statistics between the three organizations are never in sync, and we never agree of what has been issued by DSD, what DSD is having in their register, what versus what we have received and processed in payment. And reporting, as I've said, we find that our reporting also is challenged. And I think based on the extension of the court order, SASSA thought when they go back to court, then we need to have something that will show and that we can prove from our SOCPEN that this is what we have received and that we have captured on time, because it also has got its own time frame to say a court order should be processed within 10 days of receipt. Thank you, Mensache. As I've said, the purpose really is automation, also to improve on the time lapse, so that if within 10 days of receipt, we're able to capture and say, this is when it was received from DSD, we have it, this is when it was captured, and this is where the payments were made. Also to increase accountability and compliance between all the stakeholders, integration of solutions. It's one of the long term, because we would need to come up with a solution that will be compatible to all of us. We are still using SOCPEN, and you might find that Department of Justice is using whether Oracle or another, and DSD is using another one. And that becomes a process that we are looking at. In terms of the funding and the cost for SASSA, fortunately, there's no cost implications. We are doing this with the government chat, as we have done with the online application. It's internally in government, so there isn't any cost implications. We are going to go live. Go live is that all regions are going to be expected as of the 1st of July to be able to capture and scan the court orders on this new system, so that we're able to track and trace. And we are using our own internal system that is called ICAS. The dates are just talking to the internal training of our own staff. And I think that is as short to say this is what we are starting as SASSA towards the effective management of foster care, court orders, and children in foster care as well. Chairperson, let me conclude. Thank you.
Thank you very much, Ms. Sebeletso. Thank you for the extensive presentation. And judging from the presentation as well as the challenges that you have highlighted, I must indicate that as it is, the existing coordination mechanism and systems seems to be inadequate to ensure proper integration, intersectoral collaboration, as well as accountability in response to the national policy vision. And I think as a committee, we feel very strongly that through proper planning, decisive and effective leadership, and seamless coordination amongst all the relevant stakeholders tasked with this responsibility, the national response to children's protection can be realized in this country. Having said that, let me take the opportunity to also acknowledge all the participants who have joined us through the various social media platforms, YouTube, Facebook, etc. Thank you very much for taking time to be with us. We cannot see you, but we know you are with us. We really appreciate your attention and your interest in the subject. And then let me also request that all the presenters should actually forward their presentations to SIPO so that they can be shared with all the participants in the different forums, either through WhatsApp or email, etc. And those of you who might want to deposit your email addresses on the chat group, you can do so that SIPO can capture that and he can forward you the presentations at a later stage. Thank you very much. Let's then proceed to the second presentation by the Department of Social Development, which is going to be presented by the HOD, Ms. Tembeni Mhlongo, on the systems in place to process the applications, the number of foster care cases received per month, the human resources, as well as the inter-institutional challenges. Over to you, Ms. Mhlongo. Thank you very much.
Thank you very much, Chair. I just want to do some opening remarks. I will request that the director responsible for children be the one that make the presentation. I'm also not so sure, Chair, because the presentation that she had shared earlier, which was shared with the committee, she had revised it just to add some information with specific reference to human resources. Let me take this opportunity to thank you, Chair, and the members of the Portfolio Committee and the support staff, the judicial educators that are here, the Family Forum, members of the Family Forum, and also members of the Judiciary, Department of Justice and Correctional Services, and also our sister agency, SASSA, the non-profit organizations that are on the call, and also our National Department of Social Development. A very warm welcome to all of you. Chair, I just want to indicate that foster care is but one of the alternative care system in the country. And we are all aware about the challenges that we have had with regard to the foster care system. But also appreciate that it is a global system, and it is used in a wide range of placement, ranging from short to long term. And if everything goes well, a child then is afforded an opportunity of living in a family that will be able to care for their needs. Having said that, as at the end of April in Gauteng, by the 15th of each month. So for the end of May, we don't yet have the statistics. We have 57,477 children that are currently in our foster care system. And I just wanted to highlight that and also to indicate that we do work in partnership with various stakeholders and especially the child protection organizations, because they are the ones that are assisting us as a department to render this essential service. With regard to the integrated foster care management system, I think I agree with Sasa. And I think as Ms. Ntwampe present, she may highlight what is it that we have done as a department so that we can be able to also deal with that challenge because we also realize that being paper-based is one of the challenges that actually lead us not to be able to timelessly attend to some of the cases. But we have upgraded our system. The SEP CRM7 will be in a position to assist us with some of these challenges. And I think working together with other key stakeholders, we will ultimately be able to have a seamless system that will be able to identify these challenges very quickly. Chair, I'll pause here and allow Ms. Ntwampe to continue with the presentation. I'm just not so sure whether, because I heard earlier that we don't have the rights to share the presentation, whether she will be able to share from her side because she's got a revised presentation. Thanks, Chair.
Thank you very much, HOD. Ms. Ntwambe, are you able to share the presentation with us? If not, just indicate so that you can get assistance. Otherwise, proceed.
Thank you, Chairperson. Thank you, members of Portfolio Committee and Principals. Chair, I have asked my colleagues, Ms. Msibi, to share the presentation. So, Ms. Msibi, if you can please share, and then we'll continue. But Chair, just to say that with the challenges of load shedding and that, I will speak to the additions as we go through the slides. However, the final updated presentation will be sent to Mr. Nwala at a later stage, later today. Ms. Msibi? The presentation was flighted earlier on. It seems Ms. Msibi has a challenge. Can the person that flighted earlier on please flight, or Ms. Jonah Rain? Unfortunately, I can't flight from my side. I have technical challenges.
Okay, if anyone can assist with flighting the presentation, Member Nsekre or Sipho from your side, or anyone. Thank you. Yeah, if you can just make it into a slideshow.
Thank you, Chair. This presentation will be basically based on what the Department of Social Development already done, and it is in the process of doing. But Chair, before I proceed, can I just tender an apology for DDG Kabasia, who is the DDG for Social Welfare and Specialist Services, Community Development, Regions and Institutions. He was not able to attend, Chair, due to competing demand. Purpose, Chair, of this presentation is really to provide the status report in respect of foster care services, but also the provincial plan in that respect. Just to, as a matter of introduction, Chair, to indicate that social development, next slide, has a mandate to operationalize the rights of children in partnership with the designated child protection organizations, which are managed through service level agreements. The child protection organizations will be those that we normally refer to as NGOs or non-governmental organizations or NPOs. But in terms of the Act, Chair, they need to be designated to render statutory services. Also, with regard to the Children's Court decision to issue an order, is informed by the social work report that will then provide the profile of the prospective foster family, and this will have then to be supported by documents so that the court is informed and therefore it's able to make an order or make informed decisions. Chair, with regard to the foster care system, just to say that this is the system that cares for children and is actually one of the child protection interventions that we have within the department, and that is legislated. In terms of those children are placed in foster care if there is an order, and it's mainly when they are in need of care and protection. Chair, there is an interdependency and interlinkage and reliance on various department and the service is implemented optimally. Unfortunately, when one of the component is ill-functioning, Chair, then this will have an adverse effect on the functions of the system and therefore negative implication for the children concerned. Also, Chair, to say that in terms of the foster care, it is critical that we have the system is adequate, and also that we are all functioning based on the reliance. Chair, in respect of the foster care system itself, the next slide will show that childcare is everyone's business. We have all these stakeholders that are responsible to ensure that the system actually works. We have the Child Protection Organization, as indicated earlier on, which signed on or in terms of the service level agreement, and they are designated as such, and they are an extension of the department in terms of rendering this service. But Chair, also to say with regard to these CPOs, there is agreement with respective regions in terms of where their intervention lies. With regard to community, Chair, is basically in terms of identification of children that are in need of care and reporting such to either DSD and or the child protection organizations, but also to say that communities are responsible for childcare and protection. However, beyond that, the importance of the foster parents in ensuring that they monitor their orders and ensure that then they are able to go back to the respective organization when the time comes for reporting and or the order is due to lapse. The Department of Education, in respect of education and learning, Chair, its role is in admitting children. There is a requirement that we monitor the child's progress academically, but also to make informed decision in terms of do they need to be in streamlined education system, but also, Chair, to say, Chair? Okay.
Yes, proceed, we can take.
Thank you, Chair. With respect to the Department of Justice and Correctional Development, Chair, it's mainly consideration of the recommendation as alluded to earlier on, the issuing of orders in respective of the child's need and what is in the best interest of the child, but also in terms of monitoring of the orders that the court itself has issued. With respect to SASSA, I think that Ms. Maketa has really indicated what the role of SASSA is, but safe to say that they will also have the database of foster care children that are receiving the grant in the province, and their role will also be the issuing of the respective grants, but also the monitoring thereof. The Department of Health will
assist us with Road to Health card. This is basically to say, are we placing the child with the respective family that will have the resources and the capacity to actually care for the child? And also there is a need for psychological and psychiatrist report wherein the child might need such a service. Chair, in respect of the Department of Home Affairs, their main mandate in this regard is admission of children to birth and death register. But Chair, just to indicate that there is a reliance to the Department of Health in this respect for their Road to Health card, because then it will indicate where the child was born and who the child was born to, but also its main mandate is the identification documents that they need to issue. What one would want to highlight here, Chair, is that there is payment with regards to that the issuing of such documents, and in most instances our prospective and foster parents will indicate their inability to incur such costs. Chairperson, with regards to SAPS, they are key stakeholders in childcare and protection, and their main is to arrest perpetrators as when in there are cases reported to them, but also as a safety net when children are reported to them after hours. But in this respect, just to emphasize that as a circumvent to Form 30, which it is a challenge and it is issued by the Department of Social Development, and it is one of the requirements in respect of placing children in foster care. We relying on SAPS for issuing of police clearance. However, we're using this as a mitigator, but Chair, it comes with costs as well, which our foster parents in most instances are not able to pay. With regard to the Department of Social Development, Chair, the Provincial Department of Social Development has a role to play, and also the National Department of Social Development. With regard to the National Department, it will be more in terms of policy development, monitoring of the program throughout the country, but also it is a mandate of the Department of Social Development in respect of where they care, and therefore are responsible for then the issuing of the outcomes in respect of Form 30s. Chair, this is a delay in most of the programs, but yeah, we have had engagements with the Department of National Department of Social Development in that regard. With regard to the Provincial Department of Social Development, Chair, is mainly the implementation of the program, also monitoring of the implementation of the Act, policy development and guidelines, continued monitoring of performance and also of the program itself, but also key stakeholder management in respect of all the stakeholders that are involved in the respect of the foster care management and foster care program. In the next slide, Chair, is just to indicate that South African government ratified the United Nations Convention on the Right of the Children, which really lays foundation for protection of vulnerable children within the country, but also that in respect of the South African Constitution, specifically, there's the right to palliative care when children are removed from the family environment. So basically, this is to imply that every child has or a right to be cared for within a family setting. Chair, the Children's Act also seeks to operationalize this right, amongst others, to have the children's best, by having the children's best interest being protected, and foster care is one of the vehicles to actually ensure that we achieve same. In the next slide, Chair, we talk to the Gauteng City Region Accelerated Social Transformation Strategy 2030. With regard to the strategy, Chair, we just need to highlight how the GCR defines a child, and it is actually to say it's a child that enjoys every right in terms of an adequate standard of living. Child has a right to physical, mental, spiritual, moral, and social development. In this respect, Chair, one will also remind Chair that the family setting becomes an important part of that. Also, the strategy recognizes that parents might have challenges, and although it is their primary responsibility to ensure that the children's rights are met, but in instances that the parents are unable to do so, that the state must take appropriate steps to assist the parents and others responsible for children, be it the caregivers in such respect. So foster care is also one way of parents have challenges. We are able to, as a state, to assist. Furthermore, Chair, GCR, the strategy commits GCR to say that it will ensure that it provides for these rights, or children are provided with these rights, and it will be then all inclusive of education, health, psychosocial support and material assistance, nutrition, clothing and housing. In the cases where parents may not have the means to provide same. So this is mainly to say that the child should actually be treated holistically government efforts. In the next slide, Chair, I'm just outlining or linking some of the key legislative frameworks and imperatives. This will include the Children's Act number 38 of 2005, the Strict Matters Amendment Act of 32 of 2007, which will also assist in terms of ensuring that those that perpetrate against children are arrested and are also put in the register. Birth and Death Registration Act number 51 of 1992, Social Assistance Act number 13 of 2004, South African Schools Act number 84 of 1996. Chair, this is not really the end of it. There are other acts that are also impacting on this program that are considered when the Chairperson, just to indicate that there is a process that is being followed when a child is to be placed in foster care, and the process will really start with the assessment of children, allocation of the case to the social worker. There will be home visits that are conducted to really ensure that the child is where their needs will be met, and also that the parents themselves are vetted against the child protection register, or there is a police clearance in respect of stamps. The children are in school that they are required to have access to, but also in terms of all the other key stakeholders, be it if children have psychosocial needs that they are attended to, that they are the school reports, there is a road to health care cards, there is also the documentation in respect of home affairs, be it the birth certificate, and that once that is done, a report is then compiled by the social worker, and it is presented to the children's court to actually open what we called a children's court inquiry. And in respect of that, then the presiding officer through the clerk of the court will then consider the report, and when the child is deemed to be a child in need of care and protection, an order will then be issued in that regard, placing the child in need of care into
foster. In terms of Section 180 Chair of the Children's Act, a child is then in foster care if the child has been placed in the care of a person who is not the parent or the guardian of the child as a result of an order of a children's court, as has been alluded to, Chair, or there is the transfer in terms of Section 171 highlights that the transfer will happen if the child is already in foster care. It's not an order that places the child in foster care. And in terms of Section 180 of the same Act, subsection 3, a children's court may place a child in foster care with persons that are not family members. So, Chair, we normally refer to this placement as unrelated foster care placement, but the placement can also be with family members, Chair, and this is a related foster care placement, which could be the aunts and the grandparents and the siblings and that. But also, the children can be in foster care schemes, depending on the circumstances. With regard to the next slide, we're talking to the purposes of foster care, which are to really protect the nature children by providing a safe, healthy environment with positive support. But also to promote the goals of permanency planning towards family reunion, or by connecting children to other safe and nurturing family relationships intended to last a lifetime. So in this regard, Chair, is just to say that foster care as a temporary measure, it is also a goal into ensuring that there's actually a permanence with regard to the child's life, so that we don't find the child jumping from one care to the next. Also, the one of the purposes is to respect the individual and family by demonstrating respect for culture, ethnicity, and also community diversity. We need to ensure that children are placed in circumstances where their culture will be nurtured, and also they won't feel indifferent. With regard to who can be a foster parent, in the next slide, it is indicated and is regulated that the person must be a fit and proper person entrusted with the foster care of the child. In terms of proper protection register, the foster parent must be willing to be able to undertake exercise and maintain the responsibility that to provide an environment that is conducive to the development. Critical to highlight that when it comes to because the child becomes to be, the child is then cared for and not necessarily by the individual. So it is critical that such
Ms. Ntwampe,
Chair, just to indicate my apologies.
Just try and shift a bit. Thanks.
Okay, I have done so. HOD. I was speaking to the next slide, Ms. Msibi, to indicate that in respect of the human resource within the foster care program, Chair, we have a breakdown of social work managers. We have 11 of those in the province. We have social work supervisors. We have 126 of those. We have social work 118 of the cohort. Also 217 social auxiliary workers. Just approaches for that. It is not specifically for the rendering of the foster care program. Hence, they mentioned that they are rendering social work services. With regards to intake, Chair, earlier on in your comment, you indicated that there are a number of children that are entering into the system and are in need. However, they are not processed. Just to indicate, Chair, to say as at from February to April 2021, we had 5,146 intake in respect of applications for foster care placement for both related and unrelated, and this will be from both the Department of Social Development and Child Protection organizations. But also, Chair, to say that with regard to those that were accumulated, with regard to those that are accumulated prior the period that was mentioned earlier on, it will be 4,107. So, Chair, as and when we are receiving new cases, there are cases that we're taking on to backlog with regards to just intake, and therefore it becomes accumulation as such. And in terms of number of children that were newly placed in foster care during March and April 2021, it is then 1,039, which is by both the related by both DSD and CPOs, and it will be placement in foster care that is related and or unrelated. Chairperson, I think Ms. Tebelezo did talk to the issue of number of children that are currently receiving or placed in foster care and therefore should be receiving social work services. The number by the end of April 2021 was 57,447, and the number of related children in the disaggregation with regard to related and unrelated foster care placement is as follows. Those that are in related foster care placement is 49,512, but also in respect of those unrelated, it is then 7,935. Chair, I just want to highlight that with regard to related children placed in foster care, there is a High Court order in this respect that actually stated that relatives can actually have children in foster care, and that was basically because there was a challenge around the placement of children in foster care, and that has actually resulted in the number of children placed with relatives going up. Hence, at this point in time, it is in the majority. Chair, the North Gauteng High Court order was issued in November on foster care backlog. When we talk to foster care, or we talk about children, sharing them in need of care and protection, and therefore they need service, and there's a continued review of the placement. Ms. Maketa has alluded to this order, but just as a point of emphasis to say, in respect of prayer 4.1 of the order, it extends the period of suspension in respect of the declaration of the invalidity of foster care orders for a further period of 24 months. So, which means that this order will then be lapsing in November 2022. But also in respect of the same prayer, it declares that all the foster care orders that are in existence or have lapsed due to non-extension thereof shall be deemed to have been extended and shall be valid for a period of 24 hours from the date of the order. Simply, Chair, is to say that all the orders that have lapsed and all the orders that are due to lapse are to be considered
valid for the extension for the period of 24 months, which is until November 2022, or until the end of the year on which the child subject to any foster care orders turns 18 years old in terms of Regulation 2830 of the regulations of the Social Assistance Act, whichever occurs first. Chair, when the child turns 18, there needs to be a further extension, especially if the child is still in school, and that is done by the Department of Social Development. But the prayer also continues to say, all that being said, nothing stops the Children's Court during the existence of this order and or after it has lapsed from hearing a matter and making an appropriate order in terms of the Children's Act regarding any foster care application. Slide, please. Falling with the next slide, please. Thank you. So in respect to this, Chair, what it basically means, or maybe I should start here, that as a department of social development, Gauteng, we took a resolution together with key stakeholders that as much as there is a North Gauteng High Court order that declares all the orders to be valid, we will continue to present those orders to court so that there is then review of such court orders. And this order also emphasizes that the reasoning for that, Chair, is that to ensure that we don't have all the orders lapsing on the same date in November, and we overwhelmed in terms of how we're going to do it. So continuously presenting the matters to court for extension will help in staggering the orders throughout a period of time, and therefore when the North Gauteng High Court lapses, then we're not left with a high number of children that we need to attend to. In terms of this, it also says that a children's court shall, when considering the period of extension of a foster care order affecting abandoned or orphan children in the care of a family member, take into consideration the options available to it in terms of Section 186 of the Children's Act. Chair, Section 186 of the Children's Act, the child can be placed in foster care for the duration of until the child turns 18, regardless of the age of the child when was placed in foster care. Prayer 5 of the North Gauteng High Court, as was issued, indicates that is directed to effect continue to effect payment orders until the date such orders lapses as referred to above. So SASSA must pay until November 2020, and those that would have been extended, then SASSA will continue to pay. But with regard to prayer 6, it says that the department is directed to submit quarterly reports from the date of the order and file same with the North Gauteng High Court and Center for Child Law until it lapses. The department is in compliance, Chair. We do submit reports to the North Gauteng High Court and Center for Child Law on a quarterly basis. With regard to the next slide, foster care orders extended by the Children's Court as of end of April 2021, Chair. Just to say the baseline with respect to by 12 November 2020, our baseline as a province was 10,958. Of that number, we have managed to extend 1,575. There were termination in respect of 65 children were terminated from the system, and then there were variations in respect of 23. The outstanding that we need to attend to then is 9,295. Chair, safe to say that the number is moving. It's not a constant number. Every month, as and when we go into the new month, SASSA does provide us with a database in terms of the numbers that needs to be attended to in that month. So this is a moving target as it may. With regard to the next slide, Chair, the challenges and the mitigations plans that we have is to say that with the advent of COVID, we have seen that there is rotation with regard to services rendered as social workers are coming to the office on a rotational basis. However, as a remedial, there has been a call that social workers must come into the office as and when the lockdown restriction are eased. But there's also micromanagement of foster care services to prevent lapsing of orders. What we mean by this is that every case is followed through based on the database that is received from SASSA, but also on our own caseload to ensure that there is movement in terms of ensuring that these cases are really extended. Chair, the other challenge is the insufficient resourcing of the program. The remedial is that we share resources with CPO where there is a need, so that they can also be any resources, but also there is a bid for more budget. And in the advent of COVID-19, there is a need to actually compare, but also to say the reduction and renegotiation of areas of operations. We have instances where NPOs or child protection organizations are not able to render the service, or there is challenges, and that will then lead to renegotiations of such. Chair, just to talk to the issue of resourcing, to say that in respect of laptops, there is 159 laptops within the program, and there is also 159 3G cards to work managers and social work supervisors, and a limited number of social workers. But on desktops, and we have 927 of those, and that can also impact in terms of the need for social in the office during this period, and ensure that they render their service. In terms of cell phones, Chair, we have 600 phones in the program, and there are individuals allocated where there is reliance really on pool phones to ensure that everyone has an access to a cell phone. But with regards to vehicles, Chair, there is a sharing of vehicles depending on availability of same. Then home visits and will then be conducted. So I just wanted to highlight with regards to resources, Chair, but as indicated, the presentation will be updated and forwarded. With regard to limitation in accessing supporting documents such as school reports, psychologist reports, birth certificate, road to health cards, etc., there is continued engagement with the respective stakeholders. With the birth certificate, Chair, there has been an effort to actually approach the Department of Home Affairs nationally. They want the fees will be waived in respect of this program, but however, given the number nationally, then there was an indication to say provinces must actually that effort that has actually been didn't yield any required or desired outcomes. So that has been with regard to attainment of birth certificate. Chair, in the next slide, the next challenge has been dealing of Form 30s. I have alluded to that. I have alluded to the fact that the issue of police clearance is not in the Children's Act. It's not really a requirement in respect of this program. However, it has been used as a mitigation. But also some presiding officers have actually assisted in this regard to say, with the proof that you have submitted the Form 30s and you are awaiting an outcome, or you have submitted an application for clearance, police clearance, and you are awaiting the outcome thereof, and they're able to process the application for a limited period of time, be it 3 months or 6 months, as a relief in respect of ensuring that the child is taken care of and within the environment that is suitable and is safe. Chair, there is different interpretation of the North Gauteng High Court order. However, we do try and continue to implement the foster care management plan. The different interpretation, for instance, we know that there is courts that will say that they do not have the authority to actually extend the orders that have been extended by the North Gauteng High Court, for instance, and therefore they would not be able to that or review the cases that have been presented to them, and other courts will then continue to actually issue extension orders. So there is that challenge. There is continued discussion around this matter, but we appreciate that courts are independent, and therefore we try and align our respect of the court that we are working with and understanding their needs, so that, or rather their principles, so that we can then be able to extend the cases. With regard to monitoring mechanisms, Chair, and really trying to ensure that this program gets attention and gets to be taken into the space where it is highlighted. We have bilateral meetings between regional and district DSD and SASSA respectively. This is basically to try and ensure that we're streamlining processes and to ensure that we are able to come to the end-to-end. We initially had challenges with, for instance, the non-capturing of orders or the querying of orders that have been issued by presiding officers, and therefore delays in terms of the process itself. So this bilateral meetings are actually aimed to ensure that such are threshed, but also discussion on how we can improve in terms of service delivery in this program. And I think Ms. Maketa has alluded to that as well. Monitoring of the manual database by social work supervisors. I think Chair HOD in her opening remarks, she talked about the upgrade of the subsystem, and this will relief to the manual database monitoring, because as indicated earlier on, we're receiving the database on a monthly basis, which then says we need to go back and check if the orders have been captured, what is new on the table, what needs to be attended to. So it seems to take a lot of time in terms of social work supervisors' work. However, it is a system that we have in place, and we're currently managing and doing the best that we can with it. There's provincial bi-monthly meetings between SASSA and DSD. So just to to remind everyone that when we're talking about DSDs, it is inclusive of CPO, in that we have DSD social workers that are responsible for the monitoring and management of the child protection organization. We do have quarterly family court forum meetings that we attend, wherein some of the challenges are highlighted and discussed, and ways of improvement are actually discussed, and we trying to find each other in respect of how can we really ensure that this backlog is really dealt with. I think, Chair, just to say that we all want the backlog to be finalized and not to be with us anymore, but systematically there is challenges. Participation in social case management meetings by regional courts, as and when there's case management meetings, we do attend such, and such cases then needs to be attended in specific courts, and also there's then intervention to try and resolve same. We do submit reports to the risk management committee provincially, which also monitors the program and also tries to understand what the risks are and how it can assist in terms of mitigating same. Chair, we submit monthly reports to the National Department of Social Development, wherein all these statistics and even the challenges and the mitigations are highlighted. And Chair, I think we will be aware then that such reports tend to find way to the National Assembly, and then there is a resolution in this regard. This will go for quarterly reports to the North Gauteng High Court and Center for Child Law, but also, Chair, there was a resolution that we need to submit the parliamentary portfolio committee reports on a quarterly basis. So in respect of Gauteng Department of Social Development, we are compliant with the same, Chair. In concluding, Chair, one would say that the North Gauteng High Court order, as was extended, it was mainly to ensure that there's the finalization of the process of the amendment of the Children's Act, because the Act as is currently, it seems to be an impediment in terms of this program. So the amendment therefore is in place, and currently there is public comment. It is out. The bill is out for public comment, and we're hoping that the then Amendment Act will bring a relief and really define foster care in a manner that will then be possible for the extension of the orders and the effective management of the program itself. And the Social Assistance Act was also amended accordingly, and it is also with the NCOP. With regards to foster care program, Chair, it is interdependent, and that makes it difficult for one department or even a non-governmental stakeholder to function independently. However, the forums that were alluded to earlier on, inclusive of government departments and other key stakeholders, are really trying to ensure that they do their part in respect of this program, and that in their space they also try and advocate to ensure that this program is attended to for the benefit of the children. The province have strived to prioritize foster care services, beside the fact that there are challenges that have been experienced. In respect of the can we go to the next slide? In respect of the next slide, Chair, this is to recommend And to say that the summit to please note the reports on foster care and the progress made thus far, but also to note the impact of COVID-19 on the performance on foster care program. Also, the fact that we note the challenges that are within the foster care system that as different key stakeholders we're trying to mitigate against. With that being said, thank you very much, Chair.
Thank you very much, Ms. Ndwambe. Thanks for the presentation. However, your presentation, good as it was marred by a lot of background noise and some network challenges. However, it was a good presentation. Thank you very much for the presentation. Member Nseke, I see your hand is up.
Oh, no, Chair. I want to be noted because I see we're going into questions. Thank you.
Oh, okay. Yeah, I'll call for hands just now. But before I do call for hands, I do have Mr. Mandla Nkomo, who is a special guest of ours. He's in our midst, and I would like for him to share his story before I open the floor for engagements, questions, and comments. And I would also implore on the presenters to also check the chat group. There are people who might have deposited their questions or comments there on the chat group so that when you come back to respond, you are able to incorporate those responses in those questions in your responses. Please take time to go through the chat group. So at this stage, I will call upon Mr. Mandla Nkomo to come through and share his story. Mr. Nkomo, over to you.
Hello, Chair.
Yes, Mandla. Sipho, yes. Hello. Yes.
So that you can come in. Thanks.
Yes. Sorry, I missed you there, Sipho. What did you say about Butler? Is he coming in?
No, she is just experiencing load shedding, I think from 12. He was trying to move to another area. Otherwise, you can let me know and then I'll come back to you. Thanks.
Okay, thank you. Thank you very much, Sipho. Okay, members and all the participants, I would now take hands from all of you. Let me just take hands. I've noted member Refiloe and Seke. Let me just check on the panel here.
Member Magagula.
Member Magagula. IV Pakela. Yeah, so far there's just 3 hands for now. Let's start with Member Nseke, followed by Member Magagula, and IV will be the third one.
Chair, thank you very much. I'm going to start with questions and comments on the first presentation, which is from SASSA. And I want to just ask, with regards to the SASSA presentation, did the Northern Gauteng High Court ruling only apply to children who are already in the system or all new applicants as well, since the ruling was made? And then my next question is, with SAPO, South African Post Office, seeming to be running out of money, has that not become a risk to recipients of foster care grants? And then are social workers expected to do regular monitoring of grant recipients? If yes, wouldn't an expired court order have been picked up in that space? And then a comment in that presentation, I've got 2 comments there. The linking of systems, can I ask that Home Affairs also be looked as an integration? I saw that came in the second presentation, but I didn't see it in SASSA's presentation. And then, Chair, when we were doing last year, when we were looking at food relief, there was a whole plan to do integration of systems between SASSA, Department of Social Development. At that time, it was also to assist with avoiding double dipping. And I'm wondering if not the same system can be used for integration with regards to foster care, or literally a system that can be used across all the social welfare spectrums, not just one space. But I know from last year when we were doing food, that was one of the considerations. Maybe if we can get an update of how far we are with that. And then could I just ask SASSA to clarify what a kinship grant is in the space of foster care? Then on the second presentation, let me thank the department as well for their presentation. It's very nice to see the department with far more detail for us. Then I just want to ask a couple of questions to ask, are there instances where there are children placed in care without being referred for grants? And then are there any stipulations with regard to how often social workers visit the children for monitoring purposes? And then also, just because we're sitting with children now and vulnerable children, what is the legality of drop boxes now, especially when you see in the media we've got an increase of abandoned babies in our province? And then on the presentation, slide 17, Ekurhuleni looked incredibly high. It had over 5,000 cases. Is there any particular reasons why it's so much high? It's almost double the second highest region in the province. And then slide 18, may referred to insufficient resources. Chair, I want to refer you back to a meeting we had last week on budgets where we were told, no, the resources are actually sufficient. And yet here we sit in this particular presentation and we are told that there's insufficient resources such as laptops. And I'm wondering if the department can really clarify what they mean by insufficient resources. When we were doing budget, we were told that there's not sufficient resources. And then my last question is, what is being done to decrease the backlog of the Form 30s that in the system, because clearly they are a bit of an impediment to foster care. Chair, I'm going to leave it there. Thank you very much.
Thank you, Member Nseke. Can we now take Member Magagula? Member Magagula.
Thank you, Chairperson. I think my question is based on the first presentation on the impact of when there's a conflict between the survival parent and the families of the deceased parent in terms of handing over or placing the child on or children on the foster care. I mean, the survival parent would be contesting with the deceased family. What would be the outcome there, and also taking into consideration the interest of the children, if they are maybe at the point where they can decide for themselves what would be the decision in terms of that, in placing those children at the place of safety, or I mean the foster care. I think the second presentation from the department, maybe if I can, I did not follow exactly on the processes which are supposed to be followed before the placing of the child. And after placing the child at the foster care, maybe it's the foster parents, can the community be the eye of the department in terms of, because they don't have a capacity to make follow-ups most of the time. If I can observe, because sometimes those parents who want to foster children, they'll pretend as if they'll take a good care of the children or of the child, but when times goes by, the neighbors will realize that these are not a good parent, because they leave the children maybe alone, going and somewhere. And secondly, you'll find out the children are suffering in terms of maybe attending school and not being dressed accordingly. Can the public being the eye of the department, and can the department act swiftly when that is being reported? Thank you.
Thank you very much, Member Magagula. Let's take Member Engelbrecht. Oh, sorry, before Member Engelbrecht, it's Ivy Pakela that I noted, and then Member Engelbrecht, you'll be the last one. And then thereafter, I will take input from the South African Judicial Educators Institute by Teresa Horn, Miss Teresa Horn, so that she can make her presentation, because she has to leave the meeting for another engagement. So the responses by the departments will come after her short presentation. Okay, Ivy, Mayor Ivy Pakela, over to you. You can unmute yourself, Ivy, and speak if you are still here.
Okay. Hi, I'm Ivy Pakela. My question is based on social workers and the way they deal with cases of children. My question is based on how to deal with a social worker, or what must I do? Because the social worker closed the child foster grant on 2019 when the child's mother passed away. She closed the money on 2019. Till today, the money is still closed. The child was 15 years old and now she's 17 years old. On top of that, she was coming over at the house to bring up papers so that we can sign. But then there's no changes that are happening. Instead, time is going on, but then she's not doing anything to show up that what is she going to do to let off the foster money for the child. My question is based on that.
Okay, Ivy, in which capacity are you here? Where are you from? Can you just quickly identify yourself?
I'm Ivy Pakela from Endicott. I'm under a Heidelberg Ratanda.
Okay, thank you very much. Yes, Member Engelbrecht. Over to you, Member Engelbrecht. Are you still here, or have you been cut off? Okay, I see. I think the system has kicked you out. We'll take you on as soon as you come back. Let me then give Ms. Teresa Horn the opportunity to make her input. Thank you.
Thank you, Madam Chair. Just allow me to load my slides, but I see that I have not the ability to do that. Let me just see. Is it visible now?
Yes, it is visible.
Okay.
Thank you very much.
Fantastic. Good. Colleagues, thank you very much for the opportunity. And it is really very encouraging to see this stakeholder engagement, a collective engagement, for a number of reasons. I think there's no better way to start than with Tata Madiba. History will judge us by the difference we make in the everyday lives of children. And two of our previous presenters have mentioned the fact that DSD is the guardian of the Children's Act, and it is then expected of DSD to be the yardstick to show that they do have a real intent to comply with this and to comply with their constitutional responsibilities as well. And I think this is what we should start with, to say that it is an indictment on DSD that since 10 May 2011, a first High Court order had to be granted. Every second year it had to be renewed, and we are now on the 6th court order that was dealt with, dated the 12th of November 2020. And what is important is, and please just hear me out, I'm not throwing stones, I'm laying the basis why this is so important that we have the engagement that we have at the moment. Paragraph 2 of this court order dated the 28th of November 2017, which subsequently was then dealt with over and over again. The delay by the first respondent, that is DSD, in preparing and introducing before Parliament amending legislation to produce a comprehensive solution in respect of the foster care system is, and here now, unconstitutional, unlawful and invalid, and the delay in putting in place the necessary mechanisms, structures, resources to ensure that foster care systems operate in a sustainable and effective manner is unconstitutional, unlawful and invalid. So at least let us acknowledge that there's huge room for improvement. And I am not standing here as Department of Justice as opposed to you as Department Social Development. I'm seeing us as collective, as a holistic approach in order to ensure that we fix this problem. But unless we are fully aware and we acknowledge that what we are doing is not okay and is not working, we cannot fix it. And just to soften the blow, because I don't want to be seen as the one that's throwing stones, absolutely to the contrary, we ourselves feel that what we are doing is just a drop in the ocean, but the ocean would be less because of that missing drop. And being Teresa, I think I can own this from Mother Teresa. And that is what I want to encourage us before I even start with my presentation, that let us each collectively and individually do our bit and to then make a difference in the lives, and we will be able to make a difference. So I just want to, the presentation, just zooming in, for lack of a better word, on the provisions of Section 150, Section 159, which is the ordinary duration of the placement of orders for maximum of 2 years, then the all-important Section 186, which is the exception of that ordinary duration. Also Section 176, the remaining in alternative care beyond the age of 18 years. And colleagues, you will see these are all sections that have already been referred to either by SASSA or DSD. And then the foster care placement, the two options in foster care placement in Section 156. And then, sorry for that, the all-important reunification services in Section 187, and then that we consider a family member, an orphan, and abandoned as well in terms of the Act. And I'm trying to do my presentation to say, how can we fix what we have now before the new bill is in operation, because you know, there's a pearl of wisdom. We perish because of a lack of knowledge. So I really hope that with the suggestions that it will have an impact. So I want to focus first on the biggest issue that DSD is experiencing troubles with, and that is abandoned and orphaned children. And one of the questions that have now been raised by the panel also related to this issue. And there we have to first consider what is an abandoned and an orphan child in relation to a child in need of care and protection. Now, this is exact wording from the Act. A child is in need of care and protection if he or she is an orphan or has been abandoned and want to emphasize that, and does not have the ability to support himself, and such inability is readily apparent. I will come back to this issue insofar as the financial investigation is concerned, because that will also address one of the other questions that one of the panel members had. Section 1 defines an orphan, and that is very important that we first consider that as a child who has no surviving parent caring for him or her. So if there is a surviving parent, that child is per definition not considered to be an orphan. I hope that that already speaks to that one question that one of the members asked insofar as the surviving parent and the other family is concerned. Section 1 also defines abandoned in relation to a child to mean that that child has been deserted, obviously deserted, meaning literally those that we find in the veld with maybe even the umbilical cord still on, but have a look by the parent, the guardian, or the caregiver. So if that granny is the caregiver, technically that child cannot be considered to be abandoned because the child has a caregiver. It's important for us to note that. Or has for no apparent reason had no contact with the parent, guardian or caregiver for a period of at least 3 months. So this is very important that we also take note of that, because if there was no contact with that parent, per definition that child is abandoned if that failure to have had contact is for no apparent reason for 3 months. And this is where one of the biggest issues occur insofar as DSD is concerned, but I will explain it by way of what I am going to say now. So what needs to be done? And here is the first issue that happens in the court and that causes huge delays. Your act that you are the guardians for says in General Regulation 56(1), and general regulation meaning it is the regulations that has been written by DSD for DSD. If it appears to a designated social worker that a child has been abandoned or orphaned, the social worker must, there's no discretion, the social worker must cause an advertisement to be published in at least one newspaper. And we can now enter into discussion about it, but I can assure you, when I present throughout the country, I'm not even focusing on Gauteng, I'm making it general now. The first thing that the magistrates will tell you is that the social worker will look with big brown eyes to tell you and say, but there's no money from DSD. And they then accept it. Whereas in truth, first of all, the magistrate ought not to have accepted that as a reliable witness, because a social worker doesn't have knowledge of what is going in the finances of the department. Secondly, there's also a duty, a statutory duty on the social worker to do so, and the magistrate, being a creature of statute, is not allowed to deviate from that. But because of us finding ourselves in such an invidious position, we later let luck here, and we so easy use that term, but it's in the best interest of the child. Well, if we acted in the best interest of the child, we would have complied with the act, the regulations that has been made by DSD for DSD. So may I please implore on DSD, here is already a huge gap in the fact that things cannot be finalized as quickly as possible. It is also causing huge acrimony later between DSD and the NGOs, because they are being told yes, there's no money, etc., whereas it should be that the budget must make provision for it. Alternatively, if you feel that it doesn't serve a purpose, please make, as is required of you in terms of the Northern Gauteng High Court judgment, make recommendations either to have it removed or to be replaced with something that will assist your budget. But whilst this is still standing, there is no other option but to comply with that. What further needs to be done? Well, General Regulation 56 sub 2 says that when the presiding officer must determine whether that child is abandoned or orphaned, that presiding officer must, so there's also not a discretion, be satisfied that the child is abandoned or orphaned. And colleagues, that is very easy, because now we know what is defined by the Act as abandoned, what is defined by the Act as orphaned, and there is just that yardstick then. Has the child been just obviously deserted, or has the child not had contact for no apparent reason with the parent, guardian or caregiver for a period of 3 months? An orphaned, similar situation in terms of the definition. And be furnished with a copy of the advertisement. Can you see? The magistrate doesn't have a discretion. And then it really angers me when I hear that DSD submit reports and say there are magistrates that are difficult and not helping and serving the best interest of the child by insisting on advertisement, whilst other magistrates are acting in the best interest and waiving this requirement. Well, to my opinion, it is actually the other way around. And that's why let us just do what the Act expects of us to do. Then we won't cause some presiding officers to have to bend backwards in doing something what is actually illegal and against the law. Here I've shown it now to you. And the presiding officer must also be satisfied that there's been a period of 1 month that has lapsed since the publication of that advertisement. And in respect of an orphan child, you must consider a death certificate or even an affidavit in the absence of the death certificate. And insofar as an abandoned child is concerned, and here I want now to pay special attention, Regulation 56 sub 2D. You must consider an affidavit by the social worker. So it cannot be included in your report. It has to be an affidavit by the social worker setting out the steps taken to trace the child's parent, guardian or caregiver to the effect that the said cannot be traced. So the social worker has to submit in compliance with this an affidavit where it is literally step by step the steps that has been taken in order to trace the parent. Now, I can tell you one of the classic examples that I had when I was presiding in Benoni still, where the social worker just submitted a one-liner, whereabouts of the parent, of the father is unknown. When I spoke to the child, the first thing that the child said to me is, I said, when last have you seen your father? And she closed her eyes and she said, the day that my granny chased him away at the funeral of my mommy. And do you know where your dad is? 0832303837. She literally gave me the father's telephone number. These are the things that the social worker should have picked up. So the social worker, it is essential and of paramount importance that the social worker makes that affidavit. I'm going to prove to you further that this affidavit is what is to be considered by Home Affairs when a birth certificate is to be issued. And I want to point out to you that many of the issues with birth registration insofar as abandoned and orphan children are concerned is as a result of non-compliance with your own regulations 56 up to specifically. And also the magistrate must also consider an affidavit by any other person, and that would usually be the person that in whose care you're going to place this child, or the family, to say the mother just left the child here, we haven't had any further contact with the child. And it is hugely important that you as social workers do that, because it's going to cover you if there are any inaccuracies that might pop up later, which often happens. So I think it was Mr. Ntwampi that also mentioned that there's two Gauteng High Court matters that dealt with that family members can get a social grant. Well, these two matters that is being, it is actually two, SS versus the presiding officer of Krugersdorp and NM versus the presiding officer of Krugersdorp. And Chairperson, I have no problem to provide to you both these cases with a summary of these cases, because a financial inquiry must be dealt with. And it is the social worker that has to do that in her report to say, I say, despite the fact that this is a family member, the family member has a duty to maintain this child or doesn't, because there's the discrepancy between SS and MM. SS dealt with where there was no legal duty of that family member to maintain the child. And the court then said, then you don't even need to do a financial inquiry insofar as the foster care person is concerned. He can even be the richest person in South Africa. He's entitled to a foster grant. And then NM was where the child was placed in the care of the granny, which has a legal duty to maintain. And then there had to be like a three-tiered financial inquiry. First, the inquiry insofar as the child is concerned. Does that child have means? And that might seem to be like an anomaly, but that inquiry must be something. Does the child have is there a family house that should now be belong to the child? They can get rental income. Did the child parents have a pension fund that could go to this child? That child might be the child of a social worker or a magistrate who has a pension fund that will provide for that child. And therefore, that financial inquiry will therefore prove that the child has financial means and it is easily ascertainable. So please, I undertake to make these two judgments available to you. But in short, if you can just remember that you will have to indicate in your report that financial inquiry, and it is based on whether there is a duty to maintain. If there's no duty to maintain, there should not even be a financial inquiry, because in terms of SASSA, a person is entitled to foster care if that child has been placed in a foster care grant, if that child has been placed in foster care. And I just wanted to also point out in this aspect, Section 8 and 5, read with Regulation 7 of Social Assistance Act, SASSA did quickly touched on it, that a foster parent can only be a person that has got an ID number. And that ID number is only issued in 3 instances: to a citizen of South Africa, to a refugee, not an asylum seeker, a refugee, and to a person with permanent residence. So please, if you are starting with this inquiries, please consider that, because otherwise foster care grant, you cannot place the child in foster care because of the fact that that person won't be able to collect the foster grant unless he is a citizen, a refugee, or a permanent resident. And now we get to birth registration. Well, in terms of the Birth and Death Registration Act, Section 12 and Regulation 9 makes specifically provision for a deviation of the normal birth registration if the child has been found by the court to be abandoned and orphaned. And it in fact go as far as to say it is the social worker that has to submit that application. And colleagues, I want to also point your attention to the fact that when you stand there as the social worker, it is your particulars that are going to be entered into that application for a birth certificate. And that's then when the social workers quickly say, no, this is not my child. And then I remind them, but don't worry, you are covered. You have done your work. You have submitted the report. You've done the investigation. You've even submitted an affidavit of the steps that you have taken to ensure that this child is indeed abandoned. So please, when you consider to submit that, be aware that it is going to be you that is going to stand there at Home Affairs in order and with your information to register that child. But the beauty is there is provision in the Act for abandoned and orphan children to be registered. And it is quite a total deviation from the ordinary position. So yes, cost is involved, because cost is only not involved if it's in the first 30 days. So my question to DSD is, shouldn't that then also be part of a budget to say the child needs to be registered, there's cost involved, we haven't been successful with Home Affairs in waiving the cost, let's consider to as a budget item in order to address that, because that would assist the child. Then the involvement of the social worker I have dealt with, that it is crucial therefore that you have your ducks in a row when you are going to do that. So it is usually been done in terms of Section 12 and Regulation 9 of the Birth and Death Registration Act, within 60 days after the finalization. You will be expected to submit your report, that affidavit, compliance with General Regulation 56 and the court order where the child was found to be in need of care and protection. And that will constitute a proper application that will ensure birth registration. And if we can just do the small things that the Act is allowing us to do, we will really make a huge difference for all those children that are hanging in limbo and even becoming stateless. Now, the next question is the foster care placement the only option, having found the child to be in need of care and protection? And this is the thing that is so important. Foster care is but one of alternative care placement. You should try by all means to avoid a foster care placement And now, why am I saying that? Because foster care placement, first of all, mean that the child is a Chapter 9 child, therefore a ward of the state. Secondly, that all other avenues have been exhausted and found to be not possible. And the placement of that child with that specific person has also been to such an extent that the financial inquiry rendered that the person ought to be given a foster care grant. Whereas in section 156, once you found the child to be in need of care and protection, there are various orders that can be made. Section 188 sub 3, where there can be an assignment of parental rights to the foster parents, sorting out a lot of problems with regard to medical consent for operations, whatever. But the one that is so important, and especially when there's placement of families involved, that child needs to be attended to. And if that child is then found to be a child in need of care and protection, foster care is not the only option. You can even assign parental rights, care and contact by way of an order of court in terms of section 23. Then there's no foster care payment, and the people do not need to have this revisit of the review, etc. So, colleagues, if we also, yes, it is a foster care grant, foster care webinar that we are doing, but let us just also broaden our scope, because that is in compliance with the High Court order that says DSD must suggest and propose other solutions that are workable. And in terms of the new bill, their focus is shifting where there's another system that will be for placement of children with family members. And I propose that section 46 and section 23 will be a suitable order in those regards. Yeah, and then we cannot ignore the National Child Protection Register and the huge issues with that, because if we do, we are applying ostrich politics. And the National Register for Sexual Offences. So just want to emphasize that there is not in the Children's Act a requirement for a police clearance. And the National Register for Sexual Offences are at this very moment operative. The only thing that hasn't happened, but if you wanted to challenge me on that, I can provide the registrar of the National Register for Sexual Offences number to you. I have no problem to do that, and also that you can start to engage with them. That is where the justice is in fact the one that is responsible for this register. And the only thing that hasn't happened, it has not that moratorium for it to be not operational, hasn't been lifted, but it is in fact operational. And I strongly recommend that you start using it, because that will also alleviate lots of the problems that you have insofar as the issues that you've raised with the other the police clearance. But far more important is that you will realize that section 123 sub 1c says that a magistrate is not permitted to place a child in foster care if that person's name appears on the Part B of the National Child Register. And if that magistrate would do that, that magistrate is liable to as a first offender 10 years imprisonment, second offender 20 years. So to expect a magistrate to waive that is actually expecting that magistrate to place himself in a very difficult position where he can be found acting unlawfully, having placed the child at risk, and having a direct contravention with the regulation or section that was specifically aimed at the magistrate. The Form 30s is still a problem, and if we, as DSD, is not going to sort it out, I don't know. So what we have suggested is Mr. Jaco van Niekerk and myself, we have approached the specific department working with the National Child Protection Register, and there is a solution available. Here it is, Section 125, that says Form 30 is not the only way in which the information can be accessed. There are various people that can be given access to that register, and that by a mere looking at the register can inform the court that that person's name does not appear. And we don't have time to deal with it in detail, but here is the section, Section 125. DSD has the opportunity to sort Form 30 out, not by getting more people for Form 30. There is a place for Form 30, but by capacitating those people that is entitled per statute to have access to this in order to resolve that. And the affidavit is not in the Act. This is again where, as magistrates, because we know that we have to act in the best interest of the child. We know that Form 30 is just not forthcoming. Now we have, in order to protect ourselves, have even suggested for the completion of a form of the affidavit in order to cover at least those bases. That affidavit should not be part of the court record if there's compliance, because if there's compliance, you would have either the Form 30 or information that the person's name doesn't appear, and you would have information regarding the sexual offences register as well. So the affidavit, I will also make it available to your people, Madam Chair, is the affidavit that we suggest that is then being used, but may I say reluctantly so, because it ought not to be the position because of the fact that the Act provides differently. Now, one of the, I think Mr. Ntwampi also referred to Section 181, the purpose of foster care. And I think the focus there should be on family reunification. That is the primary duty, family reunification. And with respect, this is where the foster care system is lacking absolutely. Is first of all, there's no provision even in the placement report for reunification or a permanency plan. And secondly, there's just no reunification done. So Section 187 sub 1 says that reunification must be considered. And if the Children's Court is of the view that it's possible, the court must issue the placement order and on the conditions providing for a designated social worker to facilitate reunification. And there I can say on good authority that the orders emanating from various courts are indeed lacking. And Sajay, myself, I'm the only one that does the training for magistrates, are in fact really hammering on this. And I can give you the assurance, we acknowledge that there's a lack, and that is not empowering you to also do what you have to do. And justice is in fact, or the judiciary is in fact attending to that. Section 187 sub 2 also says that the social worker, the designated social worker that was appointed to facilitate the reunification, must submit the report to the Children's Court. It is a different report than the extension report. Please bear that in mind. And that is called a reunification report. Namely, Why was the child not yet reunited? Or, and the steps to be taken to stabilize the child's life. And then furthermore, reunification. The Children's Court can also consider the report and then order that it must continue or it must be terminated. And once again, the court orders are lacking, but you cannot shy away from that, because you should then say to the court, but court, what about reunification? But the court wouldn't have considered it had it not been in your report as well. I am not saying that the presiding officers are not accountable. Please, people, I am seriously addressing it with them. However, the fact is there is a dual obligation from the social worker and the court. And the court can also even place a child with the family member for an extended period of time, 2 years or even until the child is 18. And that is a placement order, or extended if it's with a family member for a longer period. So jurisdiction issues are here, the issue. Who has got jurisdiction? If you have placed the child in, let's say Benoni made the court order and Benoni placed the child with family in Van der Bijl, who has got jurisdiction? Well, the best practice is that Van der Bijl should do the extension. That is the first thing, because the child is orderly now resident in Van der Bijl. But there is a principle that says once you have jurisdiction, you never cease to have jurisdiction on a specific matter. But for best practice, colleagues, I suggest that we work together, and that it is, because we're trying now to make it uniform from the judiciary side, that it will be the court where the child is now placed that will have the jurisdiction. Who's responsible to write the report? That, because it might be a reunification report, it might be the extension report, and it might be even a supervision report insofar as the parents are concerned, and they might be from not even staying together, and they might be two different reports. These are the things that you as DSD must start to get a standard operating procedure or whatever, because I can see every time that this is where it bottlenecks, because who's responsible? Who are the role players? And this is not something that the judiciary can help with. But from my experience, may I please suggest that you have a look at these issues, because these are the issues that cause the bottleneck. What about a permanency plan? Because the Act says there must be a permanency plan. I have yet to see a permanency plan in any of the matters that has been presented to me. Are there any programs available for family preservation, mediation, family group forums, or early intervention? These are aspects that DSD are compelled to consider in terms of the chapter that deals with foster care. May I suggest that you start in serious earnesty and to look at these things. And if we can contribute, make contributions, I will even do it in my private time in order to assist with that, because this is where my passion lies. I'm not trying to throw stones here. Good. So then the sixth court order, because there were six, that was dealt with on the 12th of November 2020. It automatically extended orders until the 12th of November 2022. And the honourable member of the panel asked, is it applicable to all orders? Well, it's a very good answer, and thank you for having asked that question. It is very clear that it only relates to all foster care orders. So the child must have been found to be in need of care and protection and must have already been placed in foster care. All foster care orders made prior to the 12th of November 2020. Any order that has been made subsequent to the 12th of November 2020 doesn't fall within the ambit. So it's first of all only orders, whether they have lapsed or whatever, and it's only in relation to until 12th November 2020. And then a very important aspect that causes also huge confusion, and that I would just give you a guideline on. Once the court has intervened, so you take the order, you take the matter to the court and say, yes, we know that we've got extension until the 12th of November 2022. However, we want the court to get involved in compliance, as Ms. Ntwampi said, in order to comply. And that is then where the High Court order is now not applicable anymore, because it is now in the realm of the Children's Court where it belongs. So please be very clear, even SASSA, once the Children's Court has started to intervene in that order, you cannot rely back on the order, because now it has been subjected to the judicial review that the court intended to do. And the only reason why this blanket was given was because of the fact that there wasn't judicial overview. So my second last point, I am questioning how many are awaiting to be included in the system. And that was also a question that was raised by one of the panel members, because this High Court order is not applicable. And the Act says you can approach for a complaint by way of two meanings. You can go to the social worker, and I want to point it out, if you go to the social worker, that social worker, in terms of Section 155, that's intake, has got 90 days maximum to investigate, and then proceed to the court and either say, I have investigated, I found the matter, the child is not in need of care or protection, or I have investigated, please let's engage and start the Chapter 9 proceedings. Colleagues, you are going to agree with me. I don't think there's even a dispute about it. This does not happen. I have been made aware, and in fact, I'm at the moment busy with a matter that involves my old domestic worker, where we followed the correct procedures. I haven't even mentioned that I am involved in this. It's been 2 years that the matter is with the social worker, still trying to do the investigation before it is going to go to court. This is a disgrace. Section 53 says that the person can also come to the court, and frankly, I prefer this now. All foster parents can even can come to court, because General Regulation 6 then says the court must within 5 days make an order, and that order is going to be social worker investigate in terms of 155 and bring your report to me within 90 days. So here is a huge, huge problem. And I, with respect, question the figures that was given, namely 5,146 and 4,107, because that means it is 9,253 in total that is awaiting to be in the system. I am doubtful about that. Good, so unaccounted violation of the Constitution. This is what we're talking about. And Section 157 start talking about securing stability. And it is time that we as social workers and the judiciary start to have a robust approach, because Section 157 says you have to secure stability. And if it's a small child, he must be made available for adoption at the first opportunity, because that is how you assist a child to form a bond with the person that you place him with. So I am also going to make available, Madam Chair, a suggested format that I try to now all the newly appointed magistrates to say, please use this foster care placement order because it deals with each and every option. It's unfortunately not prescribed in the Act. I am going to root for that it should be uniform, because that will then also assist DSD in order to know when does the order lapse, when must the reunification report be submitted, when must the report be submitted of the extension report. So you see in the C section, I deal with the duration of the foster care placement and making all the options available. And then the consideration of the placement subject to supervision services. Bear in mind that it can be the foster care placement that can be supervised, the child's father and the child's mother. So it can consist of 3 supervision reports. And these are the things that you will have to address in the standard operating procedure in order to line up, iron out all these issues that are causing the bottlenecks. Reunification services should be in a properly worded court order, agreed. But remember, you as the social worker should ensure that it's in your report and that you request it. So reunification services, there is the provision for that. And then I also, in my suggested format, include what the reunification services should be, dealing with early intervention services, family preservation program. My question to DSD, honestly, do you have these programs? And if so, why don't we see them? Because if we really am acting in the best interest of the children, we would have these things in place, because this goes part and parcel with the aims of foster care and the aim primarily of reunification. There's also mediation, family group conference, problem solving forum. Do we see it from DSD? I think it is lacking. And then there's also specified skills development, treatment and rehabilitation programs. It's not that I am thumb-sucking these things. These are in the regulations and the Act. And I have just consolidated this into what I would say utopia's best court order. Monitoring is section 65. Yes, it has been reported by one of the social workers that monitoring should be part of that. But to answer the question of one of the panel members, even if the child is being placed for until the child is 18 years old, the Act says you don't need to submit a report anymore, but you still have to do home visits. And I am fully aware that this is not being done. And whether it is due to not enough capacity, that might be so, but we have to acknowledge there's a problem, we have to sort it out. And then there's auxiliary orders that can be made, even granting some parental rights to the foster parents. Good. And colleagues, I want to conclude again with Mother Teresa, because I know that it might have been harsh, but I hope that it's been trusted that my presentation was aimed at least showing the loopholes that is existing now and where we can mirror ourselves and say we can do better, and we can. If we have no peace, it is because we have forgotten that we belong to each other. Whether we DSD, whether we the judiciary, we form an integral part in the solution. Thank you, Madam Chair. That is then all from my side.
Thank you. Thank you very much, Teresa, for the insightful presentation. And I hope the department has drawn enough lessons from your engagement with them. And I hope this is not the last time that you would be engaging with them. I hope that they will explore this opportunity and your extended hand to say that you are available. And I would advise the department to really make use of your perspectives, and perhaps in part of their training, incorporate you in part of the training with the social workers, so that you can show them the other innovative ways in exploring the legal framework, so that they are able to deal with the backlog in the department. It is much appreciated, and we'll also appreciate if you can share with us the judgments as well as the various forms that you had undertaken to share with us. That would be appreciated. And I'm sure the senior managers from the department are here listening. They should really make an effort to collaborate with yourself, so that you can work together in tackling this vicious problem. And I know that you had raised a lot of important questions on the chat group, some of which you have touched on. And I would also implore them to go back to those issues, so that they can further try to deal with those issues as well as the department. So thank you very much, really, Teresa.
Thank you, Refiloe. And may I just from my side say, I've got this warm coat on today, and I remember I wore this coat the first time that I presented and assisted DSD there at Gosforth Park. And I decided, just in solidarity with my social workers and DSD, I'm going to put on this coat today to show that I really have a heart for you. And I know that sometimes I come all fighting, but it is because of my passion, and that I really think we can improve.
No, thank you. Thank you very much.
Thank you, Refiloe.
We can improve, and I think the department can do more.
Yeah.
Thank you very much.
Okay.
Yeah. Oh, you had requested to be excused at 8 o'clock because of another engagement, and I can let you go if you still have to go. Thank you so much.
All the best for the colleagues. Thank you very much.
Okay.
Bye-bye.
Chair, is it possible to ask Teresa one question before she leaves?
Yes, I'm listening.
Sorry, Teresa, this is Refiloe from the committee. I just want to ask, from your perspective, do you not think, because I'm talking also from observation, having been on the committee since 2014, and I honestly, and I think this time I'm trying to be constructive, not critical of the department. I think we do that enough in our normal committee meetings. But it seems to me, based on the reports we look at on a quarterly basis in terms of backlog of children in foster care and in adoptions, that there is a big need for our social workers to go into specializations in terms of preparation for courts and appearances in courts. And I wonder what you would say to such a comment, because I've made that statement previously, and I really, listening to you today, I feel like my concerns, which I've had since 2014, you've taken them to a new level to say, shouldn't we look at, I don't know if there's such a course that exists or some kind of training that needs to be formulated in order to address this challenge, because I'm always saying children need to be in loving homes, not in CYCCs, but ultimately they must have love. And for me, the training to upskill our social workers so that they are more competent in terms of preparation for court, doing the necessary background work, and then being competent enough to appear before a judge when they're asked all these intricate questions which you've raised here today. And I'd like to hear your comment to that. Thank you.
Thank you. I don't want to quote scripture here, but I just say it's a pearl of wisdom. We perish because of a lack of knowledge. And I really think that, yes, of course, any social worker, and I know that I'm not talking on their behalf, will welcome training, because those that I engage with, they feel overwhelmed. And it is indeed capacity building. If we can start with that, we're going to already see a huge improvement. And that's why I didn't want to sound like I'm now lecturing, because we're supposed to know these things. But it is just so overwhelming that sometimes we don't even do the basic things that we that the Act mandates us to do, compels us to do. So I'm in full support for capacitating social workers, because what you have learned at university, and when you are expected to now come and present, just the format of your form, General Form 38, your report, if you have certain pointers, you can, I don't say cut and paste, but if you know that certain things must be in that report, you are already in a way in order to address the crucial issues. It is going to make social workers' work as well as the courts' work so much easier and better. And I can assure you, what I've tried to prove here today is the bottleneck that exists. There are some solutions for the existing statutes that are in place. So yes, it's two Refiloes, no? Refiloe. Yes,
so
okay.
the chairperson.
So Refiloe is clearly a name that DSD got a passion for. Yes, I am 100% in agreement with that.
Okay, thank you. Thank you very much, Teresa, for the response, and thank you once more for making yourself available. We really appreciate your inputs, your insightful inputs.
Thank you very much. All the best.
Thank you. Honorable members, colleagues, I am now going to overlook the hands that were up and rush to take the presentation by Ms. Pravina Lazarus, who's a senior magistrate and chairperson of the Gauteng Family Forum, because she also is experiencing a load shedding and her gadget is almost on 2%. So I just want to take her before her gadget lets her down, and I'll take all the hands after her presentation. So Ms. Pravina, if you can just present to us on the mandate of the Family Forum and how the forum assists in foster care issues. Thank you very much. Over to you.
Thank you, Ms. Kekana. Good afternoon, honorable members of the Portfolio Committee, as well as my colleagues and all the other stakeholders. It is my honor today to address you regarding the mandate that we have as the Family Forum. Just a brief history on how this Family Forum came about is that I'm currently the chairperson from 2018. I'm also senior magistrate at the Springs Magistrates Court. The Family Forum was established in 2007, and it was the brainchild of the then Chief Magistrate of the Johannesburg cluster, Mr. Jonker. Mr. Jonker, I think he's now retired. The first convener was our current Chief Magistrate of the Johannesburg cluster, Ms. Sidlova, who then chaired the first forum under the authority of Ms. Cheryl Lewitz, who's also now retired. Ms. Sidlova is currently the Chief Magistrate. So basically, it was the Chief Magistrates Forum that instituted the Family Forum. And then from the Family Forum, the Civil Law Forum and the Criminal Court Forum also followed. So that is basically the brief history of the forum. The mission statement, okay, let me go first to the membership of the forum. The forum not only includes members of the judiciary, but also various other stakeholders, quite prominently represented by Department of Social Development, or obviously plays a very crucial and pivotal role, especially in foster care placements. So it's not only the Department of Social Development, but obviously including the NGOs and the child protection organizations, including the adoption agencies. We also include the Office of the Family Advocate, which assists in drawing up of reports. Department of Home Affairs also plays a very crucial role, especially with regard to birth registration and registration of children, especially those children that are illegal immigrants or children that have been abandoned and deserted. The other stakeholders includes people like from the Department of Education. Sometimes we do we invite specialist psychologists, stakeholders who there are challenges with, so that they can assist us into having valuable insight into the challenges that we face. We also have included at some of our meetings lawyers for human rights, who also plays a very crucial role when it comes to the placement, especially of foreign children and children who are undocumented. So as you can see, the membership of the Family Forum comprises of various stakeholders. Our mission statement is basically to adopt a process of peer learning and to provide support to members of the judiciary and to other stakeholders within the family law sector. So please understand that we don't only deal with the children's court matters, but we also deal with other issues in the family law sector, that is domestic violence issues, issues relating to older persons, and also maintenance. Very often there's an interplay between these stakeholders and the different family law sections, and it impacts it impacts on the children's courts as well. This platform also provides a mechanism where judicial officers and stakeholders can get together, share their experiences, discuss challenges that we face. And Teresa has touched on many of the challenges that we face as judiciaries, as members of the judiciary, as well as the Department of Social Development. And this provides a platform where we can get together, share these challenges, and find solutions to these challenges. One of the purposes of the Family Forum is also to try and create uniformity within the courts throughout Gauteng and Pretoria, and specifically to avoid forum shopping. Again, we touched on the aspects of jurisdiction, and very often there's a debate about jurisdiction, where the child is ordinarily resident at the time the report is presented to the court. These challenges are also discussed, and we try to create a uniform approach so as to avoid forum shopping. As I said, it is also a platform for peer learning, for sharing of facilities. Ms. Horn is quite often at the meetings, and she also helps to develop those forms where we exchange forms so that we can use forms and present also a uniform approach in the way that we deal with children's court matters specifically. We also use it as a platform to exchange learning material, case law, and developments. Also, obviously, amendments to legislative provisions and current legislative provisions, and to incorporate that into the learning process so that there is constant development. You know, I always say that the law is dynamic. So it's never the same, it's never stagnant, it's forever changing. And with this change, we have to move with the change, and we have to move with the developments in the legislative provisions, as well as case developments. Ms. Horn also touched on the cases that have bearing, especially with regard to the extension of foster care orders, and obviously also to create a platform where we can share best practices. In other words, when we have challenges, how do we get around these challenges in order to facilitate the mandate that we've been given in terms of the Constitution as well as the Children's Act, specifically Section 28, where we always make decisions that are in the best interest of the child. Very important also is that we try to ensure compliance with norms and standards to resolve backlogs in the children's court and the challenges we face on a daily basis. So the Family Forum meets quarterly per year, and all the stakeholders are invited to the meeting. I have them on a emailing list where we are able to discuss these challenges and to come up with solutions. All meetings are minuted and presented to the Chief Magistrates Forum for discussion. Some of the challenges and the impact of the family forum on specifically on foster care placement, which is the topic for discussion today. It provides a platform where judicial officers presiding in the Children's Court, as well as the stakeholders responsible for support services like DSD, Department of Home Affairs, the Family Advocates Office, Lawyers for Human Rights, can come together to work on the challenges. So some of the challenges that Ms. Horn has also already discussed was obviously the big problem with Form 30s. Recently, because remember we have the request for the Form 30s, this is sent to the Office of the National Child Protection Register, where we give them a period of 21 days in order to respond. Very often this is not the case, and thus the huge backlog in the finalization of foster care placements. But arising from the Family Forum meeting, the last meeting we had on the 14th of May, Mr. Fanikak, who's one of the magistrates from Tembisa, Ms. Horn, and myself, together with Senior Magistrate Ms. Naidu from Pretoria, opted to have a subcommittee where we invited the individuals or the directors in charge of the National Child Protection Register, where we put our heads together discussing the solutions that we can find to the issues relating to the Form 30s and the backlogs that have been created, and specifically focusing on Section 125 of the Children's Act, which empowers the department to allow access to various other stakeholders, including members from the Department of Education, but most specifically to social workers and supervisors and managers of social workers at a provincial or regional level, which will alleviate and go a long way to alleviating the backlog if these individuals have access to the National Child Protection Register. That is currently in the pipeline. We've met also with the individuals from the Integrated Justice System, which is obviously the IT department, to try and facilitate this allowing of access to the National Child Protection Register. Obviously, there are some challenges, but we've been given the assurance that this is in the pipeline and they are working on it. We've placed deadlines by inviting them again to in a month's time to deal with what progress has been made insofar as the integrated justice system and access to the register is concerned. Ms. Horn touched on the, even though the Children's Act does not allow for these affidavits and police clearance certificates, we've had to devise ways to think out of the box and develop ways in which we can finalize these foster care placements, or at least deal with them on a temporary basis by allowing the affidavit from the prospective foster parents together with the police clearance certificate, as well as proof that the request for the Form 30 was in fact sent to the department and that 21 days has lapsed. So what the agreement at the Family Forum was that members of the judiciary or the magistrates in the Children's Court will accept these as a mechanism to not to finalize, but to at least do the placement or grant the extension and pend the matter for about 3 to 6 months, obviously awaiting the Form 30 from the department. Obviously, some of, foster care is one of the one of many options in terms of the Children's Act, where children are found to be in need of care and protection. There's other issues with regard to, first and foremost, I think the uniform approach is that children should be removed from their family as a last resort. But unfortunately, in South Africa, the number of children that are found to be in need of care is increasing exponentially. the result is that there is forever a need for foster care homes. Obviously, the first resort is that the child be placed with next to kin or family members. Very often it's grandparents. So the reports from social development is essential. The family forum is used as a platform as well to discuss the challenges that we face insofar as the report and the lack of proper reports by social workers. So it's a platform where we come together, and there is constructive criticism. We try to find solutions to the problems, give direction and guidance into what is expected by the judiciary, obviously acting within the parameters of the Children's Act and the empowering constitution, making sure that social workers are aware that we're just not being difficult, but we need to act within the mandate that has been given to us, and that we are creatures of statute. Their reports are absolutely essential. The Refiloe just posed the question to Ms. Teresa Horn, indicating whether training is important for social workers. Absolutely, it is. And by inviting stakeholders, and especially members of the Department of Social Development, the Family Forum also provides the platform for training, although on a very limited range. However, it does give direction and guidance to social workers as to what is expected and how important their reports are when it comes to the placement of children in foster care. Reunification was touched on by Ms. Horn. I'm not going to go into that. However, there are provisions in the Children's Act that very often we find that social workers do not adhere to. It seems to me that very often, and I speak from experience presiding in the Children's Court for many years now, that the first leap is to remove their child. And that is not the mandate that we have. We need to provide remember the Act says that the child needs to be found in need of care and protection. And that is where the courts, as the upper guardian of those children, and the social workers as well, needs to ensure that that child is provided the protection. So investigations by social workers are absolutely imperative, that they do go out and do the investigations, looking into the circumstances of the prospective foster parents, ensuring that the environment in which they recommend that the child be placed is conducive to the well-being, protection, safety, and development of their child. And the ongoing monitoring purposes is absolutely essential to ensure that that child is given the required care and protection. Very often, there is no monitoring of the placements, and that is something to be considered. Also, if, as I said, removing a child from his family should be the last resort. If there are indications that that family needs a family preservation program or early intervention services or rehabilitation for parents that are probably addicted to drugs, these services must be rendered. And from my experience, very rarely do you find that the reports contain aspects relating to what measures have been taken by social development to enable these programs to try and preserve the family unit in the best interests of that child. Reunification is also a sore point and something that is sadly lacking in reports, even though it is mentioned in the Act. What is quite notable is that if children are placed in foster care, and if it's a non-related foster care, as we call it, very often these foster care parents prevent the biological parents from reuniting with their child, from having care and contact. And these are things that needs to be enabled by the social worker. The other issue is the foster care agreement that is signed between the foster parents and social development, sometimes lacking in the reports as well, which is important also to make sure that that foster parent is aware of his rights and responsibilities as a foster parent, and to also be to be made aware that part of its responsibilities is to enable reunification. So these programs that the Act touches on is something also that is discussed, and so basically the Family Forum is a platform also to empower not only members of the judiciary but also social development to identify the challenges that we face and to inspire one another to make sure that we act together as a team in ensuring that the best interests of the child is taken care of, and that we are able to fulfill our mandate in terms of the Children's Act. So that is basically the impact that the Family Forum has on the foster care placements. As I said, it is but one aspect that we deal at the Family Forum. Children's Court is just one aspect. We don't only deal with the foster care placements, but obviously other stuff like adoptions and children in need of care and contact. We also deal with maintenance as well as the domestic violence aspects and aspects relating to the older persons. So generally, that is the mandate that we have insofar as the Family Forum is concerned, and the impact that it has on the foster care placement. I hope that helps. Over to you, Madam Chair. Thank you very much for this opportunity.
Thank you so much, Pravina, and thank you for your inputs and raising critical questions in your presentation. And indeed, it is true that there is a growing need for foster care in South Africa. And I think we have noted that we are also alive to the fact that since the 2000s, our country has seen a massive increase in the number of children orphaned as a result of HIV and AIDS.
Absolutely.
As well as the resultant increase in the number of cases that has to be processed through the foster care system, as well as the tremendous strain this has placed on the entire system. But we also know that more can be done in expediting this process through the various interventions that have been proposed in this forum, as well as the department partnering with organizations such as yourselves, so that, like you said, we achieve the national mandate, that of caring for the children of our country. Thank you very much for your
the opportunity. Thank you.
Yes. Members, ladies and gentlemen, and esteemed guests, I am now going to give the HOD a space just to say something before she leaves, because she also has another engagement. And then I will take all the hands and conclude the discussions. So HOD, if you can just maybe reassure the committee, say something, especially with regards to the inputs made by the two magistrates, and in reassuring the committee in terms of exploring, the opportunities that they have been presented to yourselves as the department. If you could just say a few words before you leave, and then your team will remain with us to respond to the rest of the questions that have been raised by the members and the other participants. Over to you, HOD.
Thank you very much, Chair. Let me also welcome the two presentations from the members of the judiciary. Chair, I need to indicate that some of the questions that have been asked are things that we are well aware of as a department. I just need to highlight, perhaps to make comments on the two presentations that were made, especially with regard to the matters that they are raising, for example, on issues of other programs that need to be explored to make sure that we strengthen the foster care program. For example, the family preservation. I just want to emphasize, Chair, that perhaps some of the things don't come out clearly in the reports. Maybe that's a weakness, and maybe we need to ensure that we still ensure that our social workers outline each and every intervention that they are planning for that family, for that child, because when you place a child in foster care, you also need to develop an independent development plan. So perhaps it's not clearly outlined, but I'm noting that as a weakness in our reports, and I want to indicate that as part of strengthening the foster care system, we do plan for various trainings with our social workers. So maybe this is an area that it's we need to start to strengthen, where we focus also on report writing and also preparation for one's appearance in court. So maybe as part of us improving, because it is very critical that whatever that we do, it should be in the best interest of the child. We should always be mindful of that. So I'm making a commitment that we will sit down and relook at our plans, and perhaps also relook at the reports from all the regions, you know, just sample and say, you know, are these reports really reflecting that which they are expected to reflect? Having said that, with regard to ensuring that we also join hands, and I heard the two speakers also said they are more than willing to work with us as a department and also to train. And I think we would also explore that and say it is very critical that we strengthen the foster care system. Some of the questions that were raised, Chair, I want to speak in particular to the issues around home affairs. One of the challenges, and it's not only with regard to children that are in foster care, but you will note that we also got the responsibility for people that are homeless. We were given that responsibility in line with the Disaster Act when it was when we were faced with COVID. One of the challenges is that a number of them, you find that they've lost their IDs, and Department of Home Affairs also felt that as a department we need to provide. But we were told that the Department of Home Affairs, when a person who would have lost their family in whatever disaster, maybe there was a fire, they are able to provide that without even charging the person, because they also have got an aspect of considering, you know, the socio-economic status of a person, so that they can be in a position to also assist where possible. So we are continuously engaging with the Department of Home Affairs. We will ensure that we do that, so that we can be able to address this challenge. It's not only children who are in foster care, we also have other children that are undocumented, and we feel that, these are stateless children, and it is just unfair. Not necessarily children with parents who are migrants, but you find that they are South African children, but because at the time when the child was born, there was no proper care within that family, so the child becomes stateless. So we are looking into all those things. But coming back to the issues around foster care, I want to make a commitment and saying, Chair, perhaps we need another session where as a department we would also outline to say, we listen to this, what is our plan going forward to be able to deal with this? But I want to emphasize that some of the things that are being said are a national competency. It is a pity that the national department was not here, because even the issues around the Form 30s, it has not yet been decentralized so that we can be able to move swiftly. There's always been challenges with regard to that, and there's been discussions to say perhaps there's a need to decentralize. Chair, I will pause there and want to believe that the officials of the department that I'm leaving behind will be able to respond to some of the specific questions that were asked. I want to really apologize that I had to leave, but these are standing meetings which we have to attend on Mondays and Thursdays. So I'm expected to be there, and I didn't make arrangements for someone to represent me. Thank you so much for the opportunity.
Thank you very much, HOD. Thank you so much. I see Tebelezo also has to be excused. I don't know if Tebelezo, you want to come in after HOD, if there are specific questions that you would want to respond to. I know I have not explored all the questions because I still have one hand from member Engelbrecht that I needed to take, but I will take it still. But if you want to come in there so that I don't disadvantage you, I know you are sitting in the dark. These issues of load shedding is affecting us negatively, unfortunately, and it's beyond our control, but we have to make do with what we have. So I will allow you to chip in and say what you have to say in response to the comments or the questions that have been raised. Over to you, Tebelezo.
Thank you, Chair, and thank you to the members for understanding. I'll try and respond, whereas I think I was lucky enough, Ms. Horn also responded to the first question that came from Menzege, which wanted to clarity to say, does the ruling apply to children who are in foster care or even the new cases? I think in her presentation, she alluded to the fact that the court ruling, which I will read summarily, on section 4.1, I'll read verbatim. It's saying any foster care order, which at the date of this order, which was made in November 2020 on the 12th, is in existence or has elapsed, due to non-extension thereof, shall be deemed to have been extended and shall be valid for the 24 months from the date of this order until at the end of which the child subject to such foster care turns 18. So meaning that any foster care order that had lapsed and was in existence shall be in payment until that child reaches 18, as contemplated in the Regulation 28(3)D of the Social Assistance Act, or whichever occurs first, unless that court order is extended or is withdrawn or it's suspended or it is varied by the Children's Court in terms of Section 48(1). Then it goes further and say the second respondent, which is SASSA in this finding, is directed to effect or continue to effect payments of all foster care orders that are referred in this court order until the date of which such court order should have lapsed as referred above. So it doesn't refer to any new order. Any new order as after November, it's not subject to this court ruling. If it expires by next year at any time, it should be according to the SASSA Act regulation. That was the first. The second one was talking to the issues of SAPO about, and I laughed and smiled, about the issue that SAPO has and it won't affect any payment. No. Because the money that SAPO is paying is the money that is transferred by National Treasury. It is not SAPO's money. SAPO is the engine that therefore transfers the money and makes sure that people are paid. But it's the monies that are transferred by National Treasury for payment. There is no way that SAPO can come back and say they can't pay because it's not their own purse. It is the purse of the government, if I can put it that way. although we have challenges in terms of them closing post offices, but that is something for another day, but we're looking at it, but it cannot come and say they cannot pay. Thank you. The last one was I think Tebeni did allude to it, the one of linkages of the system, so that we also look at inclusion of Department of Home Affairs, and she alluded to the food parcel program that was done last year during COVID. In view of a processing of grants, we have access, although we're not linked, we're not aligned directly, we do have an access to Home Affairs for verification of an ID, so that we verify that this person is a South African and this person exists on the population register. Yes, we do have access. That's one of the systems. We verify that the existence of that ID when we take an application.
Thank you, Metsebelezo. I take it that was the last one, eh?
Yes, the others were for DSD, Mewa Heidelberg, and the.
All right.
Yes, and the one from Memakakula.
Okay, no, it's fine. I will then note Member Engelbrecht. I had noted you before. Unfortunately, I had to disrupt my program for the sake of accommodating all the presenters and their load shedding challenges. Member Engelbrecht, if you are still on the platform and you still want to raise a comment, please do so.
Chairperson, thanks very much. I was also kicked out, so we are all paying the price of Eskom. Chairperson, thank you very much. In terms of the first presentation that we had regarding SASSA, I would just like some clarity, please. The presenter spoke about huge sums that were being paid out. If I can just get clarification what these huge sums are that she was talking about and where they come from. That was the first question. And then the second question was, she spoke about the fraud, which is a problem. And if she could maybe just explain, how does the fraud take place? How does it happen? What are the systems that are allowing for the fraud to take place? Thank you, Chair.
Thank you, Member. Member Nsaka, I see your hand is up.
Chair, thank you so much. If we can, I think she forgot one small question that I had, which was clarity on the kinship grant, which came through. And I don't know whether we still have Senior Magistrate Pravina Lazarus. I just wanted to ask whether they ever make a recommendation through a proceeding to ask that whether a child should rather be moved towards adoption and not just foster care. Thanks.
Thanks, Member Nsefe. Yeah, before I allow the respondents to take the podium, I will just want to check with SIPO if we still have Mandla in the platform. I know he was kicked out earlier. If he is the platform, he can come in and say what he had to say in terms of the testimony that he must give. Mandla, if you can come onto the platform and share your story. I'm sorry to have delayed you, but unfortunately I couldn't let you in because you were kicked out earlier. But if you are back, this is your opportunity to say what you have to say before I take the rest of the responses from the presenters. I don't see Mandla. Okay. I will then allow for the rest of the questions to be responded to by DSD as well as the SASSA and as well as Magistrate Pravina, if she's still here, to take those responses through. Thank you very much. Metsebelezo.
Thank you, Chair. And With regard to the issue raised by Member Engelbrecht, I would like to say in explaining the large amounts, it happens when a person does not bring the court order on time. Like the example I alluded to of a court order which has already expired. It's of 2013, and the person brings that court order 2020. According to the legislation, the Children's Act and the Social Assistance Act, that person is still owed that money to them, irrespective whether the people didn't bring it. So internal controls measures, when a person brings an already expired court order, to try and mitigate any risks thereof and fraud, because those are the questions we need to ask to say, why did you not bring the court order on time? Because the assumption and the expectation from SASSA is that once the issue and the matter has been gone to court, the social worker to the parent should have ensured and monitored and encouraged that the people come and present. And what we are assuming is that previously, when the court orders were made, it would be either with payment or placement without any remuneration or payment by, I can't remember the terminology, my colleague here in Tampe will help, that says we are not going to get any assistance from the state. But that legislation since changed. And when that legislation changed, people saw a loophole, and whatever court orders they now have and might have said, no, I'll look after this child, I don't have to be assisted by the state. They saw a loophole and are bringing those court orders back for SASSA to pay. And that is where those large amounts are emanating from, because now it's a court order that is already beyond 2 years. In some instances, the court order would be still valid, but a person maybe is fostering more than 2 or 3 children, then that amount is large, because it would be above any money that is above 10,000 at a time if we have to pay. Why we're bringing it here is that we are seeing a lack of supervision thereof once we pay. Because we pay electronically, it goes to the SASSA card of that foster parent. The fraud case was similar. It was a large amount. And unfortunately for this case is because the child had already attained 18 and there was no extension order. But because there was an amount before the expiry wherein the parent didn't bring the court order, we still had to pay the person. And the person went to SAPO. And for whatever reason, I think the person didn't read correctly the letter, because for any approval of any grant, there is a letter that the person receives that will be say you are due to receive your grant on this date at any post office of your choice or at a specific bank account that the person would have given us. The person went, and I think the SAPO people looked at the amount and looked at the parent, and they only gave the person 10,000 instead of 60 or 56,000. And when the audit was done, we withdrew those files and we still established that the person was shortchanged. And that is the fraud case we're saying it's now being handled by head office and SAPO at a national level. Thank you. The issue, I think that was raised by Mema Kagula. I would request that it's more for DSD, and maybe if I understood well, I think my colleague will respond to it. the issue of where there is a cancellation of a parent, and I think it's if the other parent passes away and the child is still there, there are regulation in terms of what we would call from our side alternative caregiver. But I think my colleague Kiba will be able to explain in that situation, because they could appoint and they should appoint another foster parent if the situation allows. I hope I've responded to all the questions, ma'am, so that I can leave. I have my colleague who's still here. Fortunately, today she's working from home, Lerato, and will take all other questions that we need to respond to.
Okay, thank you very much. Any other one who wants to come in with a response from the various sectors that have made presentations? You can just indicate to me if you want to speak, and then I'll recognize you. Ms. Lazarus, are you still here? I think there was a question that was directed to yourself from Member Nseke. If you are not here, I think we can just get Member Nseke to put it in writing so that SIPO can forward it through to you. I don't see any other person who wants to respond in this case. And
Chairperson, I have another follow-up question, please.
Okay, member.
Chairperson, I just want to check, what is the child grant? Is it 350 Rand per child that we're talking about when we're looking at these grants? I mean, if we're looking at these amounts, and I'm telling you why I'm asking this, Chairperson, because we're now talking about figures of 10,000 Rand. The presenter spoke about an amount of 56,000 Rand. I'm trying to find out, how does one get to an amount of 56,000 Rand if you've got a court order and it's outstanding for 3 years? If you've got a child grant, if I assume it's 350, and if the person didn't claim for a year, that is round about 4,000 Rand. If you didn't claim for 3 years, that's about 12,000 Rand for 3 years. So where does a person come from and gets paid out 56,000 Rand? So I'm just trying to find out where these amounts come from, Chair. Sorry, if I can just get clarity on that. Thank you. Maybe I'm just misunderstanding the amounts. Thank you.
Yeah, I think you're misunderstanding the amounts, but the department can respond, because I know the foster grant is way more than the 350. But Tsebelezo, do you want to respond? Or anyone from SASSA? Okay, I see Ms. Ntwambe's hand is up. You can respond, Keba.
Thank you very much, Chair. Starting with the last question, to say the grants vary depending on the grant that has been applied for. Child support grant will be 445 Rand. That is until the 31st of March 2021. And the foster care grant is 1,040 Rands. So I hope that clarifies, Chair. But with regards to other questions that were raised, Chair, I will just go through them. We do have other senior managers in the platform, in the call, Chair, that can assist if I missed anything. With regard to Member Nteke, Chair, regarding the rendering of social work services and whether shouldn't we pick up on last orders when we rendering such services. It is true, Chair, that we are able to pick up on such, and hence we have the database of same. However, the challenge would be some of the blockages that were raised earlier on in respect of compliance documents, and also the role of key stakeholders in this
process. With regard to the issue of integration of systems to ensure that there is affluence in what we are doing, just to note that with the upgrade of SEP that the HOD alluded to, there is a possible interface with SOCPEN, which is a system that is used by SASSA for the payment of grants, and SEP7. So that will assist in monitoring these orders and ensuring that foster care, in terms of the processes that are followed, it is then we have the same database and that the children are benefiting from that. With regard to children in foster care not receiving a foster care grant, I think Ms. Horn tried to or did respond to that, but safe to say that in terms of the Children's Act, we do recommend whether the child, the foster care placement should be with foster care grant or not. But we also note that there is other court orders that the court can make in respect of placement of children in foster care and or in care, and that is section 46. With regard to monitoring purposes and norms and standards, just to say that the Act actually talks to one visit every 2 years that the social service professional should make. However, as a department, we agreed that the child should be seen every quarter to assess the circumstances and the situation, and that when the need arises, the child and the family needs to be attended to. The issue of the question around drop boxes, Chair, this is a challenge, and we are noticing that there is a mushrooming around this practice. But safe to say that there is standard of operating procedures in this regard, and the one organization that is noted and has been trained in this regard is the Door of Hope. However, if there's any other that are reported to us, we intervene and really try to assist in respect of that. There was a question from Ms. Magagula with regard to parental rights and responsibilities when there is a surviving parent. I think Ms. Horn indicated that the child is an orphan only when two parents are deceased, and that there is a process that needs to be followed by a surviving parent in such instances. Ms. Ivy Pakela alluded to the fact of foster care stopped in 2019 when mother passed. I'm not sure if this is a foster care because you won't place a child in foster care with the mother. However, if this was in terms of a foster parent that has passed, there will be a social worker that will be responsible for the family and even an organization in that regard. So one will recommend that the child be advised to approach SAME or approach social development nearest. However, if it's child support grant and the child is an orphan by virtue that the parent has passed, the child, Ms. Ivy can actually assist the child to make contact with the nearest social development or even child protection organizations. The HOD did allude to issues of family reunification, family preservations, programs that are within the department, but to say that we then need to highlight SAME in our reports to court. But where such are undertaken, the foster care grant and the foster care placement is then the child is discharged from SAME and then the child is placed with the parents. With regard to advertisement, as highlighted by Ms. Horn in her presentation, yes, the department does have a budget for advertisement, and such has been decentralized. So we do, and also it covers the child protection organizations, not only the Department of Social Development. Chair, there was the matter that Ms. Horn raised with regard to financial inquiry on our reports and the issue of the legal duty to maintain. This is also in respect of the Maintenance Act. But safe to say that in some instances you find that the grandparents, as much as they will have the legal duty to maintain, they may not afford such. Hence, you find the children are placed with the grandparents. However, that is noted, and we are aware of it. With regards to the issue of unabridged birth certificate and social workers applying as stated in the Death and Birth Register Act, Section 12 and Regulation 9. Chair, we note that, and safe to say that social workers have a number of children out there who are registered in their names, although they are not really taking care of them. However, the challenge then becomes the cost of attaining such a birth certificate is then incurred by the social worker, which then because it becomes a challenge and a burden. With regards to assignment of contact and care to interested person by order of court, that is Section 23 of the Children's Act. We note that, Chair, but further to indicate that this application has to be lodged with the High Court, and it will therefore come with costs. So we are aware of that, and where applicable, we will recommend accordingly. Section 125 of the Act, as indicated with regard to delegation of authority with regard to Form 30s and ability for provincial head of department in this instance to actually check on the register. Chair, we have tried to get such delegation as the province. However, there was challenge in that regard. But we note that with the upgrade to SEP 7, there is a possibility of interfacing of that system from with national. Therefore, that will give us relief in that regard. We note, Chair, Member recommended the issue of social work specialization. It is noted, Chair, and yes, continued professional development is critical, and it will be alleviated. But safe to say that the challenges within the program really needs to be unblocked for us to really win in this instance. Monitoring of placements and rendering of social work services, I've just indicated to say according to the Act is every 2 years, but DSD.
Musiwalo, can you please mute your mic, please? Musiwalo. Thank you.
Thank you, Chair. Lastly, from my side is with regards to Ms. Lazarus' comment regarding the enforcement of foster care agreement between social workers and foster parents. We agree, Chair, and such will be attended to. Thank you.
Thank you. Thank you very much, Keba. Yeah, I think there are no more hands. I see Member Engelbrecht. Is that an old hand? If it is, can you just put it down?
Apology, Chair, that must be a legacy land. Sorry.
Thank you very much. Yeah, and we have received a presentation or representation by the gentleman, Mr. What's his name again, Sipo? Mr. Mandla. Yes, it's a long submission, and I think in this regard, because he's not here to make the representation himself, we will take the representation directly to the department so that the department can assist him in resolving his issue or advise him in terms of what he needs to do with regards to the issue that is facing him. It sounds very urgent and very serious. So we do commit that we will forward that request to the department to speedily deal with it. I just want to check if there's any other respondent who want to make an input or think that there's something that has been left out before we wrap up and close.
Sorry, Chair, I don't have a hand. Is Tebello?
Okay, Tebello, go ahead.
I'm using the phone. I just want to comment on the issue of insufficient resources that was raised by Member Ncheche. On the presentation, we indicated that there will be we'll be sharing resources with the Child Protection Organization. And indeed, what the department is doing, as you know, that we sign service level agreements with the designated child protection organizations. Most of the time, we find that there is high staff turnover that also impact on the consistency and continuity of service. But what is happening at national level is that there is a prioritization process that is going to inform, the reviewing of the current model. And in that prioritization process, children's services are ranked as a priority, Chair. So I'm sure the funding will then be improved. Funding
Members, colleagues, and our esteemed guests, thank you very much for your engagements. And I think as the committee, we really appreciate your inputs and your insights and your engagements. And I think, as I had said earlier, that the engagements today were expected to address the real challenges. And I think indeed we have picked up on the real challenges, noting that the aim was also not to find fault with anyone, but rather to get to unblock these challenges and come up with a joint practical initiatives that will ensure that the children are placed in foster homes and that their well-being, care, and protection is safeguarded. As well as, I think the engagements will assist members of the committee in outlining the real challenges so that we can put more emphasis and pressure on the stubborn elements that are experienced by the department, so that in doing our oversight work, we are able to put the pressure where it belongs in order to help the department to undo these blockages. And we also urge the department to really have a clear plan and strategy in aggressively dealing with this backlog on foster care placements as a matter of urgency, in partnership, of course, with other stakeholders, especially the judiciary, as well as the need to upskill their social workers in terms of report writing, etc., taking into account the undertakings made by the HOD before she left the platform. So I guess that a report which will emanate from this seminar will come through, it will be processed, and all these issues that have been raised will be followed up with the department to ensure that indeed we achieve what we seek to achieve in terms of placements of foster care children. From my side, I would really like to thank every one of you for participating, but I will hand over to my colleague, Member Thokozile Magagula, if she's still here, to just give a vote of thanks and closing remarks. Over to you, Member Magagula.
Thank you, Chairperson. Chairperson, I think with today's seminar, the committee have gained a lot of knowledge, which will carry us and to do more in our work of areas. Chairperson, with your last remark, I think we have touched on some of the remark which I was going to say, but I would like to thank all the participants who were present in this platform. Our most gratitude to all of them with the information which they've gained, like us, our stakeholders and our presenters, especially the South African Judicial Educators Institute and the Gauteng Family Forum. With your presentation, it has made us that even tomorrow I can go to any court and challenge some of the cases and win them with what you have, the knowledge which you have impacted to us. I would also like to thank our department for giving us a presentation, and also that they also empowered like us where the areas they did not maybe do well. And going forward, I hope that they will make sure that they excel in those shortcomings where they've heard that they are lacking behind because of changes and time going on, changing each and every time, policies and also regulations in the court. I trust that Chairperson, our support staff with what they've also put to make this a seminar a success. Their efforts is acknowledged and appreciated. Hope that in future they'll do more than what they've done. I'd also like to thank my colleagues, my portfolio committee members, for availing yourself, making time, and also persevering that the time which was supposed to, that the seminar is to end it, you also persevere that it goes beyond. I think USASA, because we're always in partnership, I would like that you're always with us and hope that going forward, again, Pelamandla will always be with us also. I think soon we'll be meeting, seeking also information of the progress of what we have done also in your department. I think the late developments in your department with we see in other areas, you'll come in and share with us in the portfolio. But Chairperson, I think you were, I would also like to thank you. You were a good Chairperson, and you make everybody to be welcome in your space. You did not. There's no one who have said that no, but Chairperson did not give me a time to do 1, 2, 3. But everybody has participated accordingly. Even you understood that the load shedding is giving us a trouble, and you make sure that at any given time, if a person has managed to log in, you give that person a platform to say what or to raise issues which he or she wanted to say. But also, Chairperson, I hope this platform, it was not meant to be the first and the last one. Going forward, we'll have such seminars or workshops of sharing information and knowledge, and the skills that we have also gained, that will make us maybe work more with vigor and energy in our work of different areas of deployment. And to other like Pravina and Teresa, Chairperson, I think if they're not here, and the message is that thank you for bringing them to and expose them to us. Some of us, like both of them, they're in my areas of deployment. One is in Benoni, one is in Springs, where I'm residing, and I'm deployed in Benoni, Davidton, and Etwatwa. So you must know that I'll be knocking on your doors from time to time, and so please, I'll be troubling you and working with you going forward with the challenges we're facing on the ground. With that, Chairperson, I thank you for giving me this time or this opportunity to have a word to all our participants and to all our presenters, and also to all of us in this platform, even those who have not logged in, but in other platforms who have interest in what we're discussing. I thank you, Chairperson, and goodbye.
Okay, thank you. Thank you so much, Member Magagula, for representing the Portfolio Committee so well in discharging your duty. That of vote of thanks to all the participants in this platform, and maybe echo your sentiments to say that this is not the first and the last engagement. And I think this is the beginning of hard work that is going to take place behind the scenes, because then we have gained enough ammunition to engage the department on. And indeed, this was also a learning experience for all of us, because remember, oversight, you cannot oversight what you do not understand. So it's very important that we get the facts on the table, we understand the issues, the challenges, so that as and when we do oversight, we are able to focus on the problem areas. So I think you have touched on the right thoughts, and also thank everyone, the support staff, for the great work that they have done under difficult circumstances of load shedding. But we managed to pull this off, and thank you once again to all of you, and all of you who have joined us through the various platforms in the social media space, and also to urge SIPO to share the presentations with all who are interested in having the presentations. And I'm sure they do have your cell number as well. They can send you messages and continue to you, so that whatever there are issues that need to be addressed, they can forward those issues through to you, so that we as the portfolio committee can on their behalf submit those concerns through to the department. They can also make suggestions to the portfolio committee as part of the public participation. They can advise us, the portfolio committee, because we are representing them in the legislature. So we need to express their feelings and their views. Ultimately, we interact with members of society under general, so that and make Gauteng a better place to live at. So thank you very much, all of you. You are well appreciated, much appreciated, and the seminar is adjourned. Thank you. Good afternoon.
Thank you, Chair. Good afternoon. Bye.
Okay, thank you.
Thank you.
Goodbye. Okay, goodbye.
Thank you, Chair.
Bye-bye.
Thank you.
Good night. Mandla.